Body of the economic department.
He has already attained superannuation in 2014. 2014.
Salary is due for, I will file counter affidavit and whatever the admissible it will be paid.
Counsel for the University Affairs shall file his reply within 2 weeks.
Item number 6. Lordship, kindly see lecture 1 page 28. रिकवरी ऑर्डर के अगेंस्ट है जो पद देते हैं रेलिवेंट लाइन पैराग्राफ 1 है। श्री शर्मा को पूर्व में वित्तीय उन्नयन का लाभ प्राप्त होने के उपरांत दिनांक 30/11/12 को अवर शिक्षा सेवा प्राथमिक शाखा में समान ग्रेड पे प्रोन्नति पदीय लाभ के समय पुनः एक अतिरिक्त वेतन वृद्धि का लाभ देकर वेतनमान का निर्धारण किया गया है। वित्त विभाग बिहार तथा महालेखाकार का कार्यालय बिहार के द्वारा समान ग्रेड पे में प्रोन्नति के मामले में अतिरिक्त वेतन वृद्धि को अनुमान्य नहीं बताया गया है। इसका फिर नीचे कंटिका 2 श्री शर्मा के वेतनमान में संशोधन के आलोक में संपूर्ण अधिक वेतन
What is this excess recovery of amount? What is it related to?
petitioner basic school से retired headmaster से।
So your pay fixation was wrongly done.
The extra increment has been given to the petitioner.
Extra increment.
Lordship after the.
So that you are withdrawing. Is he in service?
No, he is retired.
रिटायरमेंट के बाद 1 साल बाद रिकवरी ऑर्डर निकला।
After retirement, you cannot do it.
They retired in February 2021.
Is that judgment
रफीक
of Supreme Court?
रफीक मसीह,
Now after Rafiq Masih, there has been another judgment.
थॉमस डैनियल लॉर्डशिप,
Huh?
थॉमस डैनियल।
No. With regard to pay fixation, they can make recoveries.
लॉर्डशिप एनेक्सचर 7
What was the
देखा,
post which you were holding?
लॉर्डशिप एनेक्सचर 7 काइंडली देखा जाए। लॉर्डशिप 13 में 2013
Please
में
let us know what is the latest judgment. 2022.
लॉर्डशिप थॉमस डैनियल जजमेंट तो देखते हैं अभी।
Young man, you have to prepare a case before you come to the court. And then you get a dismissal order from this court. There is a judgment called after Rafiq Masih, distinguishing Rafiq Masih. But then there is another judgment again by the Supreme Court. Now I am not going to give you all this.
Not here, lordship, sorry, lordship.
It's your brief. You have been engaged. You have to prepare your case. Before filing of a case, you must see the relevant judgments, what they are required. Not like this. Just ये थोड़ी कि client आ गया तो फटाफट पास petition लगाइए पेश कर दो. Must prepare the case at that relevant time. It should be there on your file. What are the relevant judgments in support of this? You may not bring the admission stage, but then that is the minimum which is required. पूछिए अपने colleagues से. In one of my case, in one of my orders. लेके आइए. I am not going to issue. I am not going to ask them to do anything. List again next week. Next Tuesday. Nalin Kumar.
Item number 7. Mr. Anil Bhatt.
Yes.
As it application file
माइक ऑन कर लो.
compassionate ground water.
आप माइक ऑन कर लेंगे तो हमें भी आपकी आवाज आएगी और लोगों को भी आएगी.
To appoint the petitioner compassionate ground water. The father of the petitioner died
When?
during service period on 23/4/2021.
When did you apply?
Applied 28/5/2021.
He died, he was on what post?
And the professor, post of professor, economics department, and Anugrah Narayan College.
So in the college they have this scheme of compassionate appointments. In the college and universities, do they have this scheme?
University has a scheme.
You had the university has a scheme.
Yes.
Please show. Where is that scheme? State government, we understand they have rules for compassionate appointment of dependents of deceased. Where is the scheme in the university or under UGC guidelines anywhere? Where is that scheme?
Asking.
So what is your basis of filing of the petition? It has to be on some basis.
Yes.
Please show. Everybody doesn't have a right. Like in banks, they have done away with compassionate appointments. They are only giving ex gratia. There are certain corporations which do not provide compassionate appointment. What about these universities? We would like to know from you.
For 1 week time, my madam.
Counsel for the petitioner to prepare the case and come again next.
Item number 7. Item number 9. Mr. Karandeep Kumar.
Yes.
Lordship, by the impugned order, Lordship, appointment of the petitioner has been ordered to be cancelled from the date of appointment, Lordship.
On what post was she working?
Panchayat teacher, Lordship.
Then if she is terminated, then you go there before the concerned district appellate authority.
Taking note of the para.
Did you challenge it?
Yes, Lordship.
Did you challenge that order before the district appellate authority, state appellate authority?
By the order of the district appellate and the state appellate authority has the state set aside the order of the district
State appellate authority.
And your Lordship taking note of in single cases, Lordship, same order, taking note of the.
Same order means, was it a common order?
No, your Lordship, in similar nature of the order, your Lordship, taking note of page findings recorded in page 17 of the impugned order, your Lordship, at para 23, notice is issued, order to be by your Lordship, by order dated 1/12/2022, your Lordship. Page 45 of the brief, your Lordship. Have a glance.
What is this appeal?
Appeal was preferred by the district program officer and the district education officer, your Lordship.
What is the ground?
Ground after 4 years.
After 4 years.
After 4 years, your Lordship.
What is the ground?
Ground was that the appointment process was concluded in 2007, your Lordship. And thereafter, one post was vacant, your Lordship, and against the vacant post, the application was made by the to consider, and that the district authority, your Lordship. Lordship.
Yes, what is the order passed? In this case also the similar
Yes,
issue.
Lordship has noted the findings recorded by the state appellate authority.
There is no such finding here.
Para 23 of your lordship.
Please read.
In that case also it's same finding.
No, there they said that there is a racket.
Yes, Lord. In that case also your lordship.
But
same,
here where is that finding?
that para 23, page 45 of the brief, your lordship.
Yes, please read it.
As remarked earlier, this case is one of the many cases involving concealment, misrepresentation and fraud by the appellants as well as the Panchayat authorities. Therefore, in view of the principle decided by the Honorable Supreme Court of India in the quoted cases, the authority is inclined to condone the delay in filing of the appeal and decide to case on merit. In same lines, in that case also, Lord.
In this case, my lord,
No. There that case was where the Mukhya was held to be having with the district authorities that and Panchayat secretary.
So that case, in that case,
And in a general observation was made that all appointments have been made fraudulently.
yes, Lord. In this case also, Lord.
Here the case is that you have been appointed in 2018 relating to a vacancy of 2007.
In
2006, madam.
In that
He
case,
is an applicant of the 2006, madam.
In that case-
One person, my lord, as you appointed, and thereafter, my lord, he resigned on the said post in 2012.
After having appointment and worked for up to 2012.
12, my lord.
Then you
Thereafter, my lord, he approached the district appellate authority in 2016 for the appointment on the post who are vacant due to resignation, my lord.
in that case, same order was passed in
In
that.
2016, the district appellate authority directed
To the employment unit to appoint against the vacancy of 2006, which is not exist, my lord. In 2006, vacancy was from
already,
the
yes. Once a person occupies the post
post, my lord.
I will,
and remains working for several years,
Thereafter,
Lordship, I will show
he
the
tender his resignation.
order of that court, order of the same lines, Your Lordship, same order, same thing was done in that case also.
tag along with Nikki. Learned counsel relies on an order passed by this court in CWJC 16170/22. Registry is directed to place the said file of the said case along with the present case on the next date. List again on next Tuesday for admission. Yes.
Item number 8, Mr. Rajesh Kumar Mishra.
May I please, my lords? It's a case by, my lords have already been, probably, my lords had seen one case earlier. The diploma in elementary education students, some had failed, my lords, in few papers. The compartmental examination by the Bihar School Examination Board is not being held, my lords, despite representations by the association. The association is there before, my lords. In a similar circumstance, my lords, I have, my lords, one order where my lords had granted the permission to fill up the forms for the unclear papers of session 1618. And we are also praying for that same session, my lord, 1618. The compartmental exam is not being held, my lords. That's the only prayer here, my lords.
Issue notice, tag along with CWJC 11530/22. Same order.
The notice probably were there, it's not need. The copy has been served to the Bihar School Examination Board and they are the
You
only.
file notices when nobody is appearing, you file notice.
My lords. Obliged.
Item 11, Mr. Devidas Srivastava.
May I please, Lord, sir? Lord, this writ petition is filed for direction to the respondents, Lord, to regularize the service of the petitioner who was appointed on sanction and vacant post of assistant, Your Lordship, since 2003, Your Lordship.
Show that you are working continuously.
Yes, Your Lordship.
Sure.
Lord, Annexure 3, Lordship. Annexure 3, page 17, Your Lordship. Without any break, Your Lordship, petitioner is working since 2003, Your Lord.
So it's a private college.
No, Your Lord. Constituent college. Sir.
Constituent college?
Yes, sir.
Then who appointed you in 2003? File your reply.
Principal Lordship, letter one is the appointment letter.
Principal can appoint.
That too, Lordship would see first line on the basis of discussion with the head clerk and examination controller and respect of examination controller.
लिखिए. Council appears for the university shall file reply. In the meanwhile, no coercive steps shall be taken against the petitioner, who is stated to be working as on date.
Same matter, serial number 16 of the same matter was.
16 को भी same.
Post खाली तीन है.
Next.
Item 30.
16 में भी आप ही appear हो रहे हैं?
Lordship,
दोनों cases को tag कर देते हैं.
what is, only the posts are different, Lordship.
ठीक है.
Issue involved in this case is, my lord, very simple. If my lord may turn to page number 36 of the brief, matter relates to appointment of assistant professor by the under the recommendation of the Bihar State University Service Commission. Basically, my lords, in the present case, issue involves in relation to grant of teaching experience. Page number 36, if is looked into.
What is the ground why they are not counting it?
They are saying that it is not signed as
Counter signature.
a counter signature. Milords may turn to.
That matter relates to Lordship, the University Service Commission
He is
and the
coming, Lord.
Purnia University.
You appear for?
State Lordship.
This is in the
University Commission, Mr. Chaudhary.
Mr. Chaudhary is coming just, Lords. I have sent. He is in all legs in court number 3. In the meantime,
Yesterday
Lords,
there was some case similar to matter. Yesterday we have
yesterday that is in relation to
experience only, teaching experience certificate.
that I don't know, Lords.
That teaching experience certificate वाला केस कब रखा है?
ये 23 को.
23 को.
सॉरी बुधवार मंगल था ना कल मंगल को. कल ही मंगलवार.
21st January.
हाँ यस.
Milords, may I submit one thing, Milords?
You file your reply by 21st January. Listed 21st January.
In the meantime, Milords, they will proceed. They will prepare.
At their own risk, if they do it, who is stopping? We will question their action.
To that effect, Milords, an observation.
No, nothing.
If is there,
Nothing there because I have not passed any order.
basically, Milords,
23 रखा गया था.
चेक कर लीजिए आइटम नंबर क्या था? आइटम नंबर 4 कल का जो डेट
हाँ जी.
उसकी डेट पे उसी डेट पे.
एकदम याद है, सही.
in my
Along with
case,
item
Milords,
number.
the certificate has been issued by the registrar. Then too, they are saying that it is not countersigned as per the advertisement. जिनके मन में जैसे
What is the law relating to counter?
No, Milords, it says that it should be by the registrar. Page number 36.
But what is the law relating to counter signatures? Is it required?
Law relating to counter.
वो तो अब छोड़ दिया ना आप लोगों ने पढ़ना. कोई या तो फिर जूनियर्स रखिए जो आपको निकाल कर दे जजमेंट्स. Share your income.
I'll be. Henceforth, I'll be, Milords.
Or
Yes,
we
Milords.
like the judges. We have to prepare our cases.
I'm sorry. I'm the last person to say anything like that.
रिक्वेस्ट था कल कहा गया था कि एक जजमेंट बताएंगे उसको गो थ्रू होने के लिए. नहीं
हम क्यों बताएंगे?
आप बोले थे कि
हम बोले कि है. हम क्यों बताएंगे?
नहीं आप कहते कि आप
We have
बता
not
दें.
taken that brief from yours. Sorry.
सर ने
इतना कर दिया जाता है any selection.
हम बताएंगे जब अपना जजमेंट लिखाएंगे. नहीं बताएंगे.
Any selection in between. इतना सा कर दिया.
Sorry. You have not brought that any
कल मेरे
judgment to
रिक्वेस्ट
support
पे
your-
उन्होंने कहा था कि बता देंगे.
Milords, basically,
No, we are not convinced with that aspect. There is a provision that there should be countersigned.
that has been by the registrar.
There is no counter signatures.
That is this. That counter signature तो भूल जाइए.
चलिए, date
ये
next.
regular signature है. Regular certificate has been issued by
Next.
the registrar.
Item number 14.
Milords,
Mr. Jibendra Mishra.
a request once again, Milords. Any selection subject to?
21st या 23rd जो भी डेट है उस दिन सुनिए.
Any selection subject to, Lords. Otherwise, Lords.
State also appears. State को दिया आपने?
जी दे दिया है.
State reply will file.
यूनिवर्सिटी को भी कॉपी दे दिया.
Reply file करें.
Serial number 14, my lord.
नहीं
इनका वाला जो.
इसलिए कह रहे थे.
13. Now 14 has been called.
Any selection.
Sorry.
उनको लाइन का.
No. That lines are very important. We will pass it on.
एक ही लाइन का होगा. 2 lines थोड़े होगा. I'm again requesting, Lord. Any selection, please.
Sir,
Any selection, please.
when I did not pass an order yesterday, no interim order was passed yesterday. Your case is similar to that. Both the cases.
हो जाएगा तो उसमें भी मिल जाएगा ना.
No, nothing. Not like this.
That may not adversely affect.
Merely because change of counsel, I will not pass interim orders.
He would have not requested with folded hands. I am requesting with folded hands. Additional बात आ गया.
Folded hands don't.
Additional बात आ गया.
In the court, there is nothing called this concept called folded hands.
होता है हुजूर, हम लोग तो करते हैं.
नहीं होता.
लेकिन additional तो आया ना हुजूर.
The request may be made in a very different
Yes,
forms, but those forms are not required to be recognized by the court.
Any selection कर दिया जाता है हुजूर.
Next case.
अब ले.
Item number 14, Mr. Jimal Mishra.
Salary matter, my lord. The petitioner were appointed in the year 2014, my lord. Thereafter, my lord, the payment was not made by the DPO, my lord. The petitioners moved before the District Appellate Authority. My lord, District Appellate Authority by, my lord, its order directed that to Annexure 9, my lord, this order 8/2016, my lord, that the payment should be made to the, against that order, my lord, DPO. But here, my lord, moved before the State Appellate Authority, my lord, Annexure 10, my lord, State Appeal number 577/2018, my lord. 14/12, State Appellate Authority also directed to pay the salary to the petitioner, my lord. In spite of that, when the salary was not being paid to the petitioners, my lord, then my lord, petitioners moved in, my lord, miscellaneous case number, application case contempt, my lord, 18/2019, my lord, before the State Appellate Authority, my lord. State Appellate Authority, my lord, there was a so cause was filed, and in that so cause it was mentioned that against the order passed by the State Appellate Authority, my lord, the Education Department moved before the Honorable Patna High Court, my lord, in CWJC number 5493/2020, my lord. Then it was, my lord, decided that my lord, the payment will be made, and after filing an indemnity bond by the petitioner, and that will be depend upon the result of the case, my lord. And only, my lord, the period of 22/10/2014 से 31/7/2017 तक की अवधि का ही पेमेंट किया गया उसमें. Annexure 15/1 पेज नंबर 82, my lord. और वो रीट पिटिशन भी यहाँ से ऑलरेडी खारिज हो चुका है, हमने 18/1 पर लगाया है. और that, my lord, the contempt petition filed by the, my lord, petitioner, my lord, was finally, my lord, disposed of by order dated, my lord, at page number 78, the relevant order, my lord. 7/12/2020, page number 78, my lord.
Yes.
The counsel for the applicants, however, made submission on merit of the statements made in their so cause, considering the jurisdiction invoked by the applicants. It may be not possible for this court to go into the correctness or otherwise of the order contained at Annexure H. It is a liberty to the aggrieved party to seek, page number 79, redressal of their grievances, if any, by invoking jurisdiction of the competent authority, my lord. The court, having regard to the facts stated in the show cause and the statements advanced in support of thereof, is satisfied that the order passed by this court has been substantially complied with. The proceeding is dropped, my lord. And only for that period, my petitioner is still in working, my lord. No order of termination was ever been, कहीं भी नहीं आया है, इन लोग नौकरी पर हैं. और हमने हुजूर सारी बातें जो है एनेक्चर एक देख लिया जाएगा, हमने जो अभी फाइल किया था तब कोर्ट है एनेक्सर 19 at पेज नंबर 92, the petitioners have filed a representation before the जिला शिक्षा पदाधिकारी my lord. Before that they have also filed a representation that कि उस तिथि के बाद से अभी तक वेतन इन लोग का नहीं दिया जा रहा है, और अब तो यहाँ तक है कि वहाँ हाजिरी बनाने के लिए नहीं दिया जा रहा है, ना इनको टर्मिनेट किया गया है, ना कुछ किया गया है। दोनों लोग दो विद्यालय में हैं हुजूर, और वहाँ एक माहौल ऐसा कर दिया गया है डिपार्टमेंट के इंस्टिगेशन से कि इन लोग को जो है सो नकली शिक्षक और ये वो कह के लोग एब्यूज करते हैं। एवरीथिंग आई हैव स्टेटेड एनेक्सर 19 my lord, और अभी तक ना कोई टर्मिनेशन की बात है, नहीं कोई बात है। जो इन्होंने रीट फाइल किया था अगेंस्ट द ऑर्डर पास बाय द स्टेट अपीलेट अथॉरिटी my lord, that was also rejected my lord. However, that was rejected in want of मतलब my lord non prosecution my lord, want of prosecution my lord, वो एनेक्सर 91 my lord। इंडिमिनिटी बॉन्ड हम लोगों ने भर के दिया, हम लोग वहाँ हाजिरी बना रहे हैं, हाजिरी अटेंडेंस रजिस्टर पर नहीं करने दे रहा है। एनेक्सर 19 हुजूर देखा जाएगा तो सारी बातें क्लियर हो जाएगी हुजूर। पेमेंट उन्होंने वहाँ तक किया।
The instruction is required why the payment has not been made, Your Lordship, and take instruction within period of 3 weeks, Your Lordship.
Learned comes for the petitioner states that in spite of directions issued earlier by the district appellate authority, the payment has not been made. Have you challenged this order of annexure H?
No, my lord, I have challenged the order before your lordship, my lord.
You have challenged this order anywhere? Annexure H?
एनेक्सर एच को तो हमने चैलेंज नहीं किया, उनके काउंटर में है हुजूर।
That is annexure 15.
Annexure 15, yes, my lord. I have aware of that order, my lord. But I came before this court against the order passed by the state appellate authority.
After state appellate authority has taken into consideration this document, no? And they gave you liberty that you may challenge it in contempt proceedings. It did not find it suitable.
तो इसको चैलेंज कर देंगे हुजूर, इसमें आइए फाइल कर देंगे हुजूर। बहुत परेशान है लोग, और ना अभी
परेशान है तो उसका मतलब ये थोड़ी कि आप गलत चीज को गलत तरीके
नहीं हुजूर। इनफैक्ट हमने ये सोचा था, फिर जो सजेशंस हुआ उसमें यही कि स्टेट अपीलेट अथॉरिटी ने चूंकि ड्रॉप कर दिया है तो हमने उसको लाइट में लाया है।
किया
हमने लाइट में लाया है हुजूर, उसको तो लाइट में लाया है।
It will be open to the aggrieved party to seek redressal of their grievance, लिखा हुआ है।
तो स्टेट अपीलेट अथॉरिटी का जो ऑर्डर है उसी के अगेंस्ट में ना हुजूर।
स्टेट अपीलेट अथॉरिटी के ने ऑर्डर में लिखा हुआ है कि आप annexure H को चैलेंज कर सकते हैं, which you have not. चलिए
In spite of direction been earlier earlier by the district appellate authority, the payment has not been made.
This court finds that a contempt petition was filed before the state appellate authority and show cause was issued, whereafter an order has been passed by the district education establishment officer, Patna, dated annexure 15 का लास्ट कहाँ है?
एनेक्सर 15 में
dated 28/11/2020,
yes.
whereby it rejected the claim of the petitioner. The said order dated 28/11/2020 is not under challenge in the present proceedings, while the order passed by the state appellate authority is under challenge, whereby the application for initiating proceedings against the respondent has been rejected. Learned Counsel submits that since the compliance was not made, there was no occasion to reject the proceedings initiated for contempt. I have considered the submission. The State Appellate Authority, by its order dated 7/12/2020, observed that certain teachers were granted the requisite amount of salary, while others were found to have not been working on the post. An order, Annexure H, dated 28/11/2020, was placed before the State Appellate Authority, and it granted liberty to the petitioner to challenge that order. However, the petitioner has not challenged the said order. The petitioner has not only asked this court to quash the order of the State Appellate Authority dated 7/12/2020. Para. In the opinion of this court, the order dated 7/12/2020 does not warrant any interference, as it allows the petitioner to assail the original order passed by the state government denying salary to him at appropriate forum. The approach adopted by the State Appellate Authority, therefore, is found to be in consonance with the legal propositions. Writ petition is, as against the order of the State Appellate Authority, is found to be devoid of merits. According to discretion. However, the liberty as granted by the State Appellate Authority for challenging the order of the state government dated 28/11/2020 shall remain in force.
Item 15, Mr. Kumar Kamal Nayak.
My lords, it is, my lords have referred the matter to a larger bench, my lords.
Okay.
I had also mentioned before the Honorable the Chief Justice last Thursday, my lords. The Honorable the Chief Justice said that he will constitute the bench in January.
Naturally, now you might have another someone. It's a great thing for the Patna High Court. You have two of the judges being elevated, recommended at least. And let's hope they are elevated also quickly.
We hope, my lords, that in these times of conflict between the government and the judiciary.
No, there's no conflict. These are all part of system. Everything takes its own time.
The only thing the Honorable the Chief Justice said that it has been referred to the DB. I said no. The Honorable Singhal has referred it to larger bench. He cannot refer it to the DB. My lords, he has referred it to larger bench. He has not referred it to the full bench.
Because it has to be to a larger bench. Whether it is division bench or...
I have also given the judgment along with that.
It is for the Chief Justice to examine those.
My lords, I have given the judgment also.
Both the counsels are at idem that the issue involved in the present case is similar to the issue already referred to larger bench by
CWJC number 8271 of 2021.
827 2021. Order dated 2021. White order dated 17/11/2021. The present case is also directed to be placed along with the said cases for appropriate decision before the larger bench.
Item 17, Mr. Bhola Kumar.
In the terms of Annexure 1, that is the appointment letter, page 11, and petitioner my lord has been appointed
on the post of Nagar Nikay Prarambhik
On the
Shikshak.
post of?
Nagar Nikay Prarambhik Shikshak for teaching, my lord, the student of 6 to 8, Annexure 1, page 11. But his
You have
salary,
to go
my lord.
State Appellate Authority.
He had,
No,
earlier he had
earlier, my lord has come, my lord, where when my lord, my pay scale was, my pay was stopped, my lord. Then your
Annexure
lordship,
5 at page 20.
Annexure 5, then your lordship has passed order to go before the appellate authority.
He moved the appellate authority.
And I moved
since
before
he
the,
has not exhausted the alternative remedy, namely the DPO or whatever, that's why it was not.
no, appellate authority has disposed of my application, and the salary, my lord, has been paid to me. The salary which was stopped, for which, my lord, earlier I came before this honorable, that has been paid. My lord,
Then what is,
my grievance has
the,
been redressed.
what is your grievance? What is your present grievance then?
My further grievance is, my lord, I am not being paid, my lord, the proper salary of, my lord, class 6 to 8 in the terms of appointment letter, my lord. And secondly, my lord, I am not being paid, my lord, the salary of the trained teacher. I am trained teacher, my lord, with effect from 38/10/19. So salary of trained teacher is not being paid, and the proper pay is.
That has to be, then you'll have to get it examined again by these. These are factual.
No, they have, my lord, not, when, my lord, they have released, my lord, salary, withholding, my lord, that trained teachers. So
it's a very big problem. You are not getting the state appellate authorities constituted, Mr. Counsel. The state has to get the district appellate authorities constituted. You have to make them functional. Why have you made that rule 2020?
If your lordship will
It
direct.
is unnecessary. We have already directed. We directed those to start being functional within 3 months. Those 3 months are over in April. We are in December. List is prepared and the minister sits over it and disapproves it. What is this going on?
I am not aware of. My lord, moreover,
The entire burden has come on the state appellate authority. There are only 2 members of the state appellate authority.
my lord.
My lord, in
You have
this
to go
case,
there. You will have to go there. No, we will not entertain this petition here.
My grievance has been redressed by the, my lord.
That was not, then why did you not take up this grievance at that time?
No,
You can't be filing successive petitions.
I have filed, my lord, raising all the grievance, my lord, but they have, my lord, not, my lord, redressed, my lord, this grievance, my lord, that I should be paid, my lord, in the terms of my
Where
appointment.
is that order of the state? Are you challenging that order?
No, I am not challenging because
If you say that you went to the state appellate authority,
my lord,
claiming all this,
my lord,
which you are claiming now,
my lord.
and the state appellate authority did not examine these
No,
aspects.
there, my lord, the claim was, my lord, for
That
release of salary, my lord.
that
Salary
is,
was-
you did not claim at that time.
No, that grievance was also, my lord, raised, but this was not specifically, my lord, raised.
Then you have dropped it.
Because
Now you can't take it up now.
I am concerned of the petitioner was, my lord, a stoppage of salary. That has been, my lord, paid. So he was, my lord, in the impression, my lord, the salary will be paid, my lord, in terms of my appointment letter, my lord. He is assuming, my lord, that in the terms of appointment letter, I should be paid, my lord. But that has been not paid, no, my lord, cause has been disclosed by the authority.
Any other thing?
Of the district,
Any
my
other
lord.
thing?
So, your lordship may direct, my lord, I may pay, my lord, in the terms of my appointment letter.
Lord, it counts for the petitioner states.
my lord, may I come in for a second?
You cannot.
No, I am not representing the state, rather I am representing Municipal Commissioner Munger. In this case, I am not for the state, your lord.
All right, so we are sending it back. Lord, it counts for the petitioner states that earlier the petitioner had approached this court for
Stop release of salary.
the action on the part of the respondents in not releasing the petitioner's salary. The state appellate authority, the matter was relegated to the state appellate authority, who passed an order
Contained in
on 5th July 22 directing the respondent to release the salary of the petitioner.
There is no such direction, Your Lordship. He has himself said, my Lord, that he would be representing before the competent authority, my Lord.
The state appellate authority disposed of the application, permitting the applicant to file representation, raising all his grievances before the district education officer, Munger. And in case the DO defaults, liberty was granted to approach the district magistrate Munger for ordering stoppage of payment of salary to the respondent DO. In compliance of the orders, the petitioner approached the DO who has released the petitioner's salary. However, the grievance of the petitioner has not been redressed completely, as the salary has not been paid in accordance with the
appointment letter.
Terms of the appointment letter as alleged by the petitioner. He is therefore again before this court praying for fixing his pay scale to scale 8 with effect from 9/1/2015 and increment of 15% with effect from 1/4/21 and to pay salary of trained teacher with effect from 29/2019. Stop. The prayer as noticed above, is required to be examined on factual aspects by the concerned district appellate authority / state appellate authority in terms of the rules of 2020, and the petitioner will have to raise the said grievance before the concerned authority, who will examine the matter, examine the claim of the petitioner after giving due opportunity of hearing to the other side. The case, if the appeal so filed, shall be expeditiously disposed of. Petition is accordingly disposed of.
Item number 80, Mr.
इनकी
Raj
अटेंडेंस मार्क कर देना जिसकी
Petitioner was appointed against the class 3 developed post on compassionate grounds. My Lord, at the time of the appointment, the petitioner was having B.Ed degree and he has not been granted 10th place. This is the ground.
He was class 3.
My Lord.
He was not teacher.
Against the post of teacher, since post was not available at that time, therefore he was appointed.
Was he appointed as a class 3 person or was he appointed as a teacher?
Class 3.
Then how can you claim as a teacher?
And he is on deputation district education officer, the office of district education officer.
He might be there anywhere, but he is not a teacher. He has never been appointed as a teacher. Where is the occasion of? Let him remain as a class 3. There is no trained pay scale for trained teachers, trained in the class. B.Ed will not give him any benefit.
My representation may be disposed of.
For what? Your representation, you don't have any claim?
Then I withdraw this up.
Counsel for the petitioner, after some arguments, please to withdraw the petition, dismiss that withdraw.
Sir, appears. Item 90, Mr. Vipin Bihari.
Appeal, Your Lord. My Lord, in this case, the petitioner was appointed by the Lecture 1, my Lord, in portions of the order of the Apex Court, my Lord. That is in page number 35, my Lord.
This order has been passed. You are working as a what post?
My Lord, they were appointed, he was appointed as an assistant teacher, my Lord, in portions of.
So his appointment has been cancelled, no?
And now I want to show, my Lord, the petitioner, after the long litigations, my Lord, he was appointed as an assistant teacher in portions of the order of the Apex Court, my Lord. Consequently, thereafter in 2012, my Lord, he has joined again the respective post, and since then, my Lord, he is rendering the service to the satisfaction of the concerned authority, my Lord. But subsequently, by Annexure 7, my Lord, Annexure 6, his appointment is cancelled with a retrospective effect, my Lord, by giving a references of the letter of which was issued in 2014 by the Education Department, my Lord, when I have no concern with that said letter, my Lord. And so far this issue is concerned, my Lord, it has been considered by this court repeatedly, and it has been held, referring the order of the Apex Court, that since the appointment has been made, so the appointment which has been made, that cannot be disturbed by any authority or by the court of law also, my Lord. In that connection, I have annexed one judgment and I am giving two judgment.
No judgment required. You are correct on that principle. They cannot have interfered. Yes?
My Lord, the
Who is that officer? Where is that order? Which is the impugned order?
Impugned order is in
Annexure 6, my Lord, 59 page.
That has been passed by the DPO and DO by Begusarai.
It is informed that the district education officer, Begusarai, has proceeded to terminate the services of the petitioner with retrospective effect, relying upon circular issued by the Joint Secretary Education Department dated 21/5/2014. Whereas the petitioner was appointed in terms of a judgment passed by the Supreme Court in the year 2012, and the circular of 2014 would have no application on him. Learned Counsel submits that unnecessary litigation has been forced upon the petitioner, and there have been already judgments passed by this court holding that the authorities have no jurisdiction to interfere with the services of a teacher who has been appointed in terms of the judgment passed by the Supreme Court. In spite thereto, the district education officer has taken this action, issue notice to the district education officer to remain present in the court on the next date. District Education Officer Begusarai on the next date. This case on 3rd January.
My Lord, with great respect, my Lord, in the meanwhile,
District Education Officer Begusarai, who had passed this order on 30th September 22, as well as the present District Education Officer holding the post.
The then and present.
We will initiate contempt proceedings against him if he does not withdraw the order.
I have no.
my Lord,
You can you can always give instructions to your officers.
my Lord,
Do not allow this kind of unnecessary litigation being forced upon this court. If we can impose cost on them for filing frivolous petitions, the government officers are equally
will be going to initiate by your lordship.
Lord,
I have no
Unnecessary
on
litigation.
the
Lord, in meanwhile, if your lordship,
order passed by your lordship.
meanwhile, if your lordship,
We will pass orders when we pass a judgment.
Yes.
This is an oral information to you.
अगर meanwhile वो जो order कर दिया
No,
जाए,
we won't be staying it. Wait.
Item 20, Mr. J. Prakash Sharma.
Make believe, your lordship. Petitioners are the second phase appointed block teacher, my lord. They have applied in the 2008, my lord. Their counseling were held, my lord, but appointment letter has not been given to him, my lord. Then they have moved before the district appellate tribunal, my lord, who has passed the order by the annexure 3, my lord, at page 50, my lord, and directed the authority to start the counseling and appoint the eligible candidate within 30 days, my lord. And thereafter, my lord, petitioners were appointed by the competent authority, my lord. Now, the state appellate authority by the annexure 1, my lord, the appointment of these petitioners have been cancelled, my lord. Though they are working, my lord, but the appellate authority has been passed, my lord, the state appellate authority, my lord. They are the block teachers in the block of Noorsarai in the district of Nalanda, my lord.
Order कब पास हुआ था डिस्ट्रिक्ट अपीलेट अथॉरिटी का?
14 में.
2014 में.
My lord.
And that was not complied with.
And that has been complied later in lecture 5 series.
When?
In 18, my lord.
In
2018, my lord.
After 4 years.
My lord. That has all been.
And they did not challenge that order at that relevant time.
No, my lord. They never challenged. Once our appointment has been made, my lord, thereafter they had come. It is not the private litigant, my lord. Rather, the state has come forward to litigate the matter, my lord. No private person has come to challenge the same, my lord.
But you did not take this argument of delay before the state appellate authority. On merits, what is your how the order of the state appellate authority is bad?
They are saying that the cut-off date was 2010, my lord, and the state come with the third phase appointment has been started, and the post which were allotted to the second phase, my lord, that has been merged in the third phase, my lord, and the mode of appointment has changed. So the appointment made thereafter, my lord, is illegal, my lord. This is the stand of the appellate tribunal.
When was the third phase started?
After 12, my lord. After 2012, my lord. But we are the applicant.
You filed an appeal before the state district appellate authority in 2010.
No, it was. I have filed in 2014, my lord. Since they were
before the state district appellate authority,
my lord,
you had gone in 2010. So where is the occasion?
They were the interveners, your lordship.
Huh?
They are the interveners.
The question is that the appeal before the state appellate district appellate authority
Yes, your lordship.
was from 2010.
Yes, your lordship.
Now after 2012 is the third phase.
But the
If the litigation is going on in the court,
selection.
can a person be denied because you have changed the scheme later on?
But the selection process was over in 2010, your lordship, and after that they.
That is what they challenged it, huh? That they were not giving due appointment.
Yes, your lordship.
And they came before the state appellate or district appellate authority.
Yes,
District appellate authority passed an order in their favor in 2014. You were required to comply with that order. You slept over it for 4 years.
We were, DPO has issued an appointment letter for all this. The main infirmity as per the state.
Nothing. Leak issue note. The council for the state accepts notice, shall take instructions, file its counter if it so chooses. That accounts for the petitioner submits that the petitioners had preferred were granted benefit by the district appellate authority Void its order dated 30/4/2014. Void order dated
स्टेट अपलेट ऑथोरिटी का है एक
State Appellate Authority का कब का है?
26/5/2014 में appeal was of 2010 is decided on 26/5/2014
26/5/2014 in an appeal decided appeal number 352/2010. The State Appellate Authority has set aside the appointments made in compliance of the order of the District Appellate Authority by improved judgment dated 1/11/22 on the ground that the new rules had come into force from 2012 and the next phase selection had started.
And there are other grounds also.
And the council submits that the petitioners were already before the District Appellate Authority in an appeal pending since 2010 and therefore would not be affected by the change of rules of 2012. Matter requires to be examined. In the meanwhile, the effect and operation of order dated 1/11/22 passed by the State Appellate Authority shall remain state.
My lord, in resolution number 7 and 8 में बिहार शरीफ के बदला में नूर सराय के बदला में बिहार शरीफ हो गया है, that may be permitted correct.
आप करेक्शन करें, एप्लीकेशन में कहिए.
Item number 21, Mr. Ranjit Kumar Singh.
My lord, petitioners are non-teaching employee of Mahila College, my lord, and their admitted dues, my lord, SCB and arrears of differences of salary has not been paid till the date, my lord. And other similar circumstances, one Ramesh Prasad Singh has filed a writ petition before this honorable court, which has been.
You are working on the post of
head color typist.
महिला कॉलेज में ना?
महिला कॉलेज में.
कौन सा है महिला कॉलेज? गवर्नमेंट का है,
कॉलेज।
किसका है? यूनिवर्सिटी का है?
भागलपुर यूनिवर्सिटी my lord. Now
अफिलिएटेड है
जी my lord.
या कॉन्स्टिट्यूएंट कॉलेज है? क्या कॉलेज है? प्राइवेट कॉलेज है क्या?
नो नो my lord.
एडेड कॉलेज है?
अफिलिएटेड कॉलेज है.
हाँ तो एड मिलती है ना कॉलेज को यूनिवर्सिटी से
जी.
वहाँ जाइए.
यूनिवर्सिटी से नहीं, गवर्नमेंट कॉलेज है
तो
भागलपुर यूनिवर्सिटी अब मुंगेर यूनिवर्सिटी में आ गया है ये कॉलेज हजूर. सिमिलर एक
कौन सी यूनिवर्सिटी में आ गया
जी? मुंगेर यूनिवर्सिटी में आ गया है. और
मुंगेर यूनिवर्सिटी को तो आपने पार्टी नहीं बनाया?
नहीं, उससे भागलपुर यूनिवर्सिटी को पे करना है. भागलपुर यूनिवर्सिटी को पे कर
डायरेक्ट पे कर देगी क्या आपको?
नो माय लॉर्ड. भागलपुर यूनिवर्सिटी को
बनाइए पार्टी बनाइए. पिटिशनर्स दिखाया या आप बना लोगे?
बना.
Counsel for the petitioner wants time to implead the Munger University where the petitioners are presently working.
अभी
Please stop for 3 weeks. 2 weeks कर दो.
इन कोर्स ऑफ डे हम बना.
कैसे बना देंगे? कोर्स ऑफ द डे आपको फाइल दे दे.
लेकिन हजूर मेरा सबमिशन
कैसे
हम दो सब बना लेंगे जो टाइम दिया गया.
बनाइए.
हजूर भागलपुर यूनिवर्सिटी पेमेंट किया है.
सुनिए आपको बनाइए.
Item number 22, Mr. Prabhakar Kumar.
Yes. Where is Mr. Prabhat Kumar?
22, Mr. Prabhakar Kumar.
this matter relates to selection matter. हिंदी के लिए हमने असिस्टेंट प्रोफेसर के लिए आवेदन किया था, बिहार यूनिवर्सिटी सर्विस कमीशन को कंडक्ट करना था। हम एलिजिबल कैंडिडेट हैं, हमको इंटरव्यू लेटर नहीं भेजा हुआ। कट ऑफ मार्क्स रखा 78, लेकिन हमको कट ऑफ मार्क्स से ज़्यादा 84 मार्क्स है हुजूर।
कॉल नहीं किया?
कॉल नहीं किया। और
मार्क्स क्या है हुजूर, हम रिकॉर्ड पे लाते हैं।
सिमिलर मैटर हुजूर हिंदी विभाग में ही जो विषय में दिया, तो उसमें पेंडिंग है हुजूर के कोर्ट में। इन्होंने खुद हमको एलिजिबल डिक्लेयर किया हुजूर। नोटिस जारी किया, उसमें दिया कि हम एलिजिबल हैं। हिंदी विषय का है हुजूर, और भी फाइल हुआ था केस, तो उसमें
इसके बाद तो आपने रिजल्ट डिक्लेयर कर दिया ना?
हाँ,
ये 15 दिन का टाइम तो बोला, फिर नहीं कर दिया।
15 दिन
ये वही वाला केस है ना?
यस, 15 दिन के बाद किया हो सर। और इनका कट ऑफ जो है हुजूर, कट ऑफ मार्क्स से कम है, इसलिए इनको इंटरव्यू में कॉल नहीं हुआ है। एलिजिबल ये हैं, लेकिन 3 टाइम्स ऑर्बिट में ये नहीं आते हैं, इसलिए
ये तो कह रहे हैं कट ऑफ से ज्यादा इनके मार्क्स।
ये इनका एक्सपेक्टेशन है, लेकिन व्हाट नंबर ही हैज रिसीव्ड फ्रॉम द सब्जेक्ट एक्सपर्ट
देखा जाए हुजूर,
दैट विल ब्रॉट ऑन रिकॉर्ड बाय द नेक्स्ट काउंटर थ्रू काउंटर माय लॉर्ड।
ये कहते हैं कि हमको नहीं है, ये कहेंगे ना हुजूर। हम जो हमारे पास सर्टिफिकेट है, हम जो पास किए हैं, हमारा जो जर्नल है, तो वो सारी चीज़ों के आधार पर हम इसमें लिखे हैं हुजूर कि हमको कितने कैसे है। पैराग्राफ 23 में देखा जाए हुजूर, हमने उसको लिखा है कि कैसे कैसे हमको 84 मार्क्स है हुजूर। जब हमारे हिसाब से 84 है, तो इनके हिसाब से जब कट ऑफ मार्क्स इन्होंने 78 रखा है, तो 84 हमको है, तो क्यों नहीं इन्होंने कॉल फॉर किया?
यस, नहीं हो सकता है हुजूर, इसलिए नहीं हो सकता है कि 100 मार्क्स का असेसमेंट है हुजूर। 77 मार्क्स में कोई कंफ्यूजन नहीं होता है, जितना ये एक्सपेक्ट करते हैं उतना मिलेगा, अगर इनका रिकॉर्ड टेस्टिमोनियल सही है तो। नंबर 1। 23 मार्क्स हैज बीन अवार्डेड बाय द सब्जेक्ट एक्सपर्ट कमिटी with regard to the articles, with regard to the awards, with regard to the whether the 5 points PhD degree has not been submitted or submitted. These factors are to be assessed by the subject expert. So differences came there कि वहां पे इनका एक्सपेक्टेशन होता है कि मेरा जो है ये आर्टिकल है 5 है तो 10 मिलना चाहिए, बट होता क्या है कि आर्टिकल प्रॉपर नहीं होने के चलते, इन सब्जेक्ट नहीं होने के चलते सब्जेक्ट एक्सपर्ट उसको कटिंग करते हैं। दीज आर अंडर द प्रोविजन ऑफ द स्टैट्यूट, इट हैज सब्जेक्ट एक्सपर्ट मेंबर्स, माने प्रोफेसर्स लेवल के जो आते हैं, जो स्क्रूटनी करते हैं, वो डिसाइड करते हैं। तो वही नंबर अवार्डिंग में जो है कंट्राडिक्शंस होता है कि इनको एक्सपेक्टेशन ये है लेकिन दिया गया ये है। यही डिसीजन, इसी के चलते ये कुछ स्टूडेंट जो है यहाँ पे अपना एक्सपेक्टेशन और आयोग के रिजल्ट में डिफरेंसेस है।
हुजूर पीआर रिव्यूड जर्नल में हमारा प्रकाशित है, और ये कह दें कि पीआर रिव्यूड जर्नल में हमारा प्रकाशित नहीं है।
एडवर्टाइजमेंट, जस्ट शो द एडवर्टाइजमेंट रिगार्डिंग असेसमेंट ऑफ मार्क्स।
असेसमेंट ऑफ मार्क्स माय लॉर्ड 7.2 में है हुजूर।
एडवर्टाइजमेंट कहाँ है आपका?
7.2 क्लॉज में ये लगाए शायद नहीं है, ये लगाए नहीं है।
एडवर्टाइजमेंट ही नहीं लगाया आपने?
नहीं लगाया है ये। 7.2 में हुजूर
लगाए तो है, ये
लगाए हैं हम लगाए हैं, हम लगाए हैं।
नहीं लगाया। Where is that assessment of marks?
7.2 क्लॉज में है हुजूर, हम बिल लेके नहीं आ पाए।
नहीं, ये बता रहे हैं इन्होंने जो मेंशन किया है,
पेज 78 हुजूर, पेज 78 बॉटम में, पेज 78 हुजूर, 7.2 क्लॉज। और ये 7.2 के मुताबिक ही जो हमारा कैलकुलेशन है हुजूर, वो 84 मार्क्स है। इनके कैलकुलेशन के जो विज्ञापन है उसके हिसाब से ही हमारा 84 पॉइंट है हुजूर। इसलिए उसके मुताबिक ग्रेजुएशन में 13 पॉइंट
पोस्ट ग्रेजुएशन में 23 पॉइंट, नेट में 5, पीएचडी में 30, आर्टिकल 5 में 10 और अवार्ड में 3। उसी गाइडलाइन के हिसाब से हम जोड़ के कह रहे हैं हुजूर, कहीं अतिरिक्त नहीं कह रहे हैं, इनके मुताबिक हम कह रहे हैं।
बता रहे हैं अवार्ड में जैसे कि
you file your reply.
अवार्ड में हुजूर एक भी विद्यार्थी को नहीं दिया गया, चूंकि एनजीओज के द्वारा दिए गए अवार्ड को नहीं कंसीडर करना है, ये एसओपी दिया हुआ है आयोग को, एक्सपर्ट को। तो एनजीओज के जितने भी अवार्ड आते हैं एनजीओज के द्वारा दिए हुए, वो अवार्ड नहीं दिए जाते हैं नंबर, अनटिल अनलेस द अवार्ड नॉट।
लेके आइए सर्कुलर, क्या है
जी, इनका क्या है, हम स्टेटस ला देंगे
इनका स्टेटस नहीं, आपने किस बेसिस पे बनाया है मार्क्स,
और किस बेसिस पर हमको नहीं दिया है।
दैट इज व्हाट जी काउंसिल फॉर द कमीशन states that the claim of marks as set up by the petitioner is incorrect, and it's time to place before this court the method and manner in which the marks were awarded for research publications, awards, and
टीचिंग एक्सपीरियंस।
टीचिंग एक्सपीरियंस
हम नहीं कह रहे हैं जो
इनका नहीं होगा, मैंने उस पैराफैमिलिया जो 33 मार्क्स का है।
ये केसेस पेंडिंग है?
हाँ, सब पेंडिंग है।
ये भी हिंदी के ही है?
हाँ, हिंदी के ही सारे।
List this case along with CWJC 1511/22
तो इसको सेपरेट ही रखा जाना, इसलिए वरुण उसमें
and connected petition
के साथ रखा जाए,
इसलिए ये सब टाइम लग जाएगा, हमको ये आ जाएगा केस।
लिस्ट आउट कब की डेट है?
2 वीक्स के बाद
इसकी डेट ढूंढ लीजिएगा ऑन द सेम डेट।
Item 23.
And then for 1 week time,
covered with Ataur Rahman case.
Ataur Rahman, which clause? Which?
One, she has failed in the examination. She has failed in the examination.
Failed in the examination. Yes. H या B? Check कर लीजिए। Disposed of.
Our going counsel is in my lord, so kindly 1 week time, my lord.
एग्जाम में फेल हो गए ना, ट्रेनिंग एग्जाम में।
मेरी तो हमको नहीं पता है, my lord।
ये बता रहे हैं ना काउंसिल, then you don't put in your appearance. Let council appeal further. State informs that the issue involved in the present case stands already covered by the judgment passed by this court in Ataur Rahman. B.
24.
Lordship, this application I have filed for direction upon the respondents to ensure payment of the salary, etc., and retirement dues of the petitioner. The petitioner, Lordship, was appointed in a project Girls High School in the district of Jamui. There are on 3rd of July 1984. Thereafter, he retired in January 2007. Then, Lordship, in 2008, his service was regularization.
Project Girls High School.
Ji.
What is this Girls High School project?
Project is a scheme of Lordship of the state government of 1980, in which a scheme was formulated to open 6 and 50 girls high school in each district where there is no any girls high school. And then this project school was
continued.
Year-wise, the scheme was made that in 1980-81, 150 school will be opened. Then in 1982, 83, 84, but in 1984-85, 450 schools were opened. And since there was no resources with the government, then it was decided that where there are private schools managed by the private managing committee will also be taken over by the government. Lordship, these are the project. Then Lordship, dispute arises regarding approval of services of the teachers who were appointed by the private managing committee and all that. Then this.
But was it this post pensionable?
Lordships.
Under a scheme, how can that be a pensionable job?
Of course, Lordship is a government job.
Show that it is pensionable service.
Lordship, it is a government job. Now the government has fully taken over those schools.
These schools have been fully taken over?
Yes.
And your earlier period of service has been counted?
Yes.
Where is that order?
Yes. Lordships, my service was, एक मिनट केवल क्लियर कर देते हैं, 2008 में my regularization was rejected by the government. Then I moved before this honorable court. Lordship, in a writ petition of 2013, which was allowed by this honorable court, that is annexure 4 at page 17. On the ground of overage, at the time of appointment, I was considered to be overage.
हमें तो समझ में नहीं आया इस ऑर्डर में क्या लिखा है
जी
हाई कोर्ट ने व्हाट इज द ऑर्डर
Lordship, actually there a full bench was held in this court. Lordship, 3 judges bench.
But what is the order?
Order it is covered by an order of
But what is that order?
Order that petitioner of that earlier writ, Lordship, he was appointed as overage. His minimum age was expired at the time of appointment. But in the light of full bench judgment, it was allowed. And thereafter this Lordship, this writ was allowed. And then Lordship, that judgment has been considered in this
So
case.
they said that all right, you will continue.
Yes.
That's
Continue
all.
and then,
Even though you were overage, but you should be allowed to
Yes.
continue. That's all.
Lordship, thereafter my
Really
service,
that pensionable service is to be treated as pensionable.
thereafter my service has been approved.
Everything. But you tell us when your service became pensionable.
Yes.
Yes तो कह रहे हैं बताइए तो सही.
Lordship, that has been fully approved by a notification of the state government, by the order of the governor.
Where is that?
Lordship, annexure 7 at page 22.
Please read it. Where does it say?
जिन शिक्षकों की द सेकेंड पैराग्राफ लॉर्डशिप, जिन शिक्षकों की मान्यता 25/1/2000 से दी गई है के द्वारा अनेकों याचिकाएं दायर कर 1/1/1989 से सेवा मान्यता एवं वेतनादि के भुगतान का दावा किया गया था, उन याचिकाओं में से याचिका संख्या 100 माननीय उच्च न्यायालय द्वारा माननीय उच्चतम न्यायालय के आदेश को संदर्भित कर सदृश्यता की दृष्टि से सभी शिक्षकों की सेवा मान्यता एवं वेतनादि का भुगतान दिनांक 1/1/1989 से किए जाने का आदेश पारित किया गया। माननीय उच्च न्यायालय के आदेश के अनुपालन में वर्ष 1984-85 चरण के विद्यालयों को ऐसे सहायक शिक्षक जिनकी सेवा मान्यता 25/1/2000 के प्रभाव से दी गई है की सेवा मान्यता 1/1/1989 से देते हुए वेतनादि का
File your reply after 8 weeks.
Item 25, Shri Jitendra Kumar.
Yes.
Lordship. So this is an application for issuance of an appropriate writ to the official respondents here, Lordship, so that they don't obstruct my discharge of public duty that I'm performing as a Gram Kacheri Secretary, Lordship.
Gram Kacheri Secretary?
Your Lordship.
What is that?
Your Lordship, they are appointed on contractual basis, Your Lordship, in Bihar. They run their ground level kacharis, Your Lordship. They come under the Sarpanch.
Then?
Under the supervision of Sarpanch, Your Lordship. So, I was appointed in 2007, Your Lordship. I was discharging my official duties as diligently as I could. Then there comes a new Sarpanch after winning an election in 2011. Now he shifts the office from where it was located to a private place, according to his own whim and fancy. I start writing representations after representations saying कि ऑफिस को शिफ्ट कर दिया गया है, मुझे चाबी नहीं दी जा रही है, वो न्यायालय चला नहीं रहे हैं, वो सिर्फ शनिवार को आते हैं घंटे 2 घंटे के लिए और फिर चाबी बंद करके चले जाते हैं. This was my grievance. I started writing representations after representations. Lordship, may I kindly come to Lordship.
Who are you?
I am the Secretary, Lordship. Gram Kacheri Secretary, who's appointed on contractual basis. I'm in service since 2007, Your Lordship.
Where is your appointment?
Your Lordship.
Where is the appointment order?
Your Lordship, it's Annexure 1. At page 12, Your Lordship.
Yes.
Yes, Your Lordship. Then my representations would follow, Your Lordship, from Annexure 2 onwards. I start writing representations that he is acting in violation of the rules. He is not letting me perform my duties. He is not providing me with the financial records that are to be maintained by me, Your Lordship, in my official duty capacity. Subsequently, Your Lordship, I also write to the DM. My 4th representation is to the DM, Your Lordship. DM orders an inquiry wherein he highlights my grievances to the block officer. Block officer intends to take an action, but because he says that there is deficient information being supplied by the DM, I am unable to take an action. So till date, Your Lordship, there is no action that has been taken. One Sarpanch comes, goes, another comes, goes, but the malpractice is the same on the ground, Your Lordship. It is located in a private place. They run it according to their own women fancies. There is nothing that is being done for the public, Your Lordship. In their own counter affidavit, Your Lordship, that they have filed, may kindly see, Your Lordship, in their own counter affidavit, Your Lordship, at para 11, Your Lordship, their counter affidavit. If I may read it out, Your Lordship, para 11 of their counter affidavit. That it is stated that serious allegations has been raised in the present writ application against the Sarpanch, Gram Kachari, Bakarpur. Therefore, the answering department, video letter so and so, requested the DM Vaishali to inquire into the matter. Consequently, the DM Vaishali has informed the answering department, video letter and so that in an inquiry conducted by the district Panchayat Raj officer.
Had the notices been issued to these Sarpanch and all? No fixed respond number. You appear for this video and all?
State here, yes, para 10 of the counter affidavit filed on behalf of the respondent number 4 to 9. So cause issue to Sarpanch, Your Lordship. para 10 और पेमेंट के लिए डायरेक्शन दिया गया है कि इनको पेमेंट किया जाए. परसेंटेज स्टेटस क्या है?
9 and 10. Just one notice to respond number 8, 9 and 10 by ordinary as well as registered post. Returnable 5 weeks. Dusty.
Item number 26, Mr. Nikhilesh Kumar. Mr. Nikhilesh Kumar.
Yes, what do you
Lordship,
mean?
I am for the state in this case, and it is being taken first time, Lordship, and brief is not located today, Lordship.
Where was this person appointed? The petitioner, but no one appears for the petitioner. The petitioner claims that she has been wrongfully denied appointment on the post of Anganwadi Sevika at Nima Anganwadi Center, District Gaya, and a person, respondent number 6, has been appointed on basis of her submitting forged and fabricated educational certificates. She claims that she had 85 merit points while he respondent possessed 70.28 merit point. The respondent number ये पहले वाला छोड़ो, point वाला जो part है she is further states that the selection process of Anganwadi worker was cancelled by the CDPO Mohanpur on 28 June 2012, and again the process was started in 2013. She applied wherein respondent number 6 was shown to have 74.85 merit points, while she possessed 70.28 merit points. It is alleged that respondent had produced false and fabricated educational certificates, which resulted in placing her at a higher merit than the petitioner. He approached, she filed a complaint to the district magistrate. Whereafter the selection process was cancelled. Again, the process of selection was initiated in 2014, wherein petitioner was placed at merit 77.28, and respondent was placed at with merit 69.85. The said selection process was again cancelled, has again been postponed. Feeling aggrieved, the petitioner has approached this court. The respondents have filed their counter. And pointed out that there were several complaints made with regard to the selection process, and therefore the selection process was cancelled. As and when the Aam Sabha is convened, the selection process shall be conducted in terms of the new selection guidelines, wherein the petitioner can also participate. Keeping in view of aforesaid facts, this court finds that no interference is warranted in the process of selection which is underway. Writ petition is wholly misconceived, is accordingly dismissed.
Item 27, Mr. Ram Subhash Singh.
Lordship, may I point out, the arguing counsel is no more. So kindly adjourn this matter so that new arrangement may be done.
It is informed that the counsel for the petitioner expired during COVID.
Yes, ma'am.
During COVID, and no one appears for the petitioner. A notice be sent to the petitioner by the registry, petitioners by registry, to engage a new lawyer or take a decision whether they want to continue to press the writ petition after the case be listed thereafter.
Item 28, Mr. Harinder Pratap Singh.
This petition is filed by appointment of compensate ground after quashing the Annexure 7, serial 3, my lord, page 40, on the basis of law laid down by the division bench of the Honorable High Court, and that basis on the division bench, the state government issued the circular, and the similar case is decided by the Honorable single judge, my lord.
Yes.
We have filed a counter affidavit in this case, and the relevant paragraph is paragraph number 8 and 9, wherein we have specifically stated that it appears from the proceeding of the meeting of the district compassionate appointment committee dated so and so that the application of the petitioner was placed before the committee for consideration, but the committee rejected the application of the petitioner on the ground that his father was initially appointed in the work charge establishment, and the Personal and Administrative Reforms Department, Bihar, Patna, has directed by letter number 46 dated 21/1/2004, Annexure 4 of the writ application, that the benefit of the compassionate appointment is not admissible to the dependents of such government employees who had initially appointed in the work charged establishment. Further, in paragraph number 9, Your Lordship, that it appears further that aforesaid direction of the Personal and
You have some rules framed here? with regard to dependents of deceased dying while in service route?
In fact, Your Lordship,
Do you have some rules rules framed by the government?
at present, Your Lordship,
Page
that-
57,
may I- that is
57. After the order of the division bench struck down the.
It was taken back. This is Annexure 9, what I am just placing before Your Lordship. That it appears further that the aforesaid direction of the Personnel and Administrative Reforms Department was subsequently withdrawn by the said department by letter number 3647 dated 30/4/2005. That is Annexure 9 of the rate application. And it was directed that the benefit of compassionate appointment will be admissible also to the dependents of such government employees who had initially appointed in the work charge establishment and die in harness. There, in the light of division bench judgment, also it is covered, he is entitled for that.
And the same fact is, my lord, decided by the Honorable Single Judge, my lord, on the basis of the division bench circular, my lord.
Issue involved in the present petition is no more res integra in view of the judge passed by the division bench in case of Dilip Kumar Bhattacharya versus State of Bihar, 2004, Volume 4, PLJR 889, wherein it has been held that even a work charge, even the dependents of a work charge employee would be entitled for the similar benefit of compassionate appointment as being allowed to the other employees of the government of Bihar. The petitioner has been denied consideration for appointment on compassionate grounds solely on the ground that father was working on work charge basis. It would be appropriate to quote the judgment passed by the division bench, para 14. Keeping in view thereto, keeping in view as above, the order rejecting the claim of the petitioner. What's the order?
Annexure 7.
Annexure 7.
To the rate application.
Page 40, my lord. Item 3.
Rejected claim of the petitioner.
Item 3. Annexure 7.
Order to make a decision dated 14 June 2004, rejecting claim of the petitioner for compassionate appointment is set aside. The petitioner, the respondents are now directed to consider the case of the petitioner and offer compassionate appointment to him. The question of overage on account of pendency of the petition shall be overlooked for the purpose. Allowed.
May the Honorable Singh same judgment, my lord, on the basis of division.
क्या करे नहीं लिखा है?
तीन आने भाई. ठीक.
Allow भी petition उसके
My.
Item number 29.
In this case, I pray for some accommodation. My file is missing, my lord. So,
my lord, the matter relates to appointment of post of constables, my lord, and we have filed the counter affidavit also.
This is 2004.
My lord.
Afflux of time they have become redundant. I have said so.
Yeah,
several of them have been disposed of.
This is the position, my lord.
That is there, no? By a flux of time. The petitioner claims appointment on the post of constable under the advertisement issued in the year 2004 on the vacancies which have remained unfilled. In the opinion of this court, selection process initiated in 2004 cannot be allowed to be treated to be continued for years together. More than almost 10 years have gone by a flux of time. Therefore, the prayer made by the petitioners has become redundant and odious, and is accordingly, the writ petition is therefore accordingly dismissed as having become infructuous by a flux of time.
Item number 30. Please. Dhirendra Kumar Jha.
This, the grievance of the petitioner has been redressed.
Counsel for the petitioner submits that the grievance of the writ petitioner has been redressed. Accordingly, the writ petition is disposed of as having become infructuous.
Item number 31.
जो इसमें एक सप्ताह का समय दिया जाए, तो ये इंस्ट्रक्शन लेते हैं पेमेंट हुआ है कि नहीं हुजूर, पेमेंट हुआ है
नहीं आपके पास,
उसमें एक बार समय दीजिए, पूछ लेते हैं, तो काउंटर भी नहीं
दिया है ना, काउंटर एफिडेविट।
जी जी, सप्लीमेंट्री हमने दे दिया कि इंटायर अमाउंट हैज बीन,
वाओ, दैट इज व्हाई विल नेवर कम।
ट्रेजरी अफसर को भेज दिया गया, उसी समय ट्रेजरी अफसर को भेज दिया गया।
वो बताइए कहाँ पे लिखा है?
मिलॉर्ड में सप्लीमेंट्री काउंटर बड़ी मिला पारा 4, 5 and 3, 3, 4, 5.
Petitioner, by way of this writ petition, had prayed for payment of his arrears of salary due as for the various periods as mentioned therein. A supplementary counter affidavit has been filed on behalf of respondent 3 and 5 along with the copy of order dated 17/9/2016 wherein it has been which reflects that the petitioner has been paid all his due amount. The order dated 17/9/2016 is not under challenge before this court. Keeping in view thereto, the writ petition is dismissed as having become infructuous, as the grievance of the petitioner stands already redressed.
Item 32.
Attendance marker.
Deepak Kumar Sinha.
So 5 is placed somewhere, give 2 weeks time.
Somewhere? Has been placed somewhere? It should be in this court or in another court, or where?
Sir, in office. Senior office.
Anganwadi worker.
Sir?
This is a case relating to Anganwadi worker.
Sir, I don't know. I instructed only this to say.
So, take this file, government council file.
My lord,
and the counter affidavit from him. Prepare a new file and argue the case on the next day. When? Next Wednesday? Next Wednesday. Give her a copy. अपनी फाइल दे दीजिए, दोनों दूसरी बना लेंगे. Counsel for the petitioner states that she has misplaced the file. The counsel for the respondent may make available his own file so that a duplicate file may be prepared. This case again on next Wednesday. Yes.
Item number 33, Mr. Dilip Kumar.
My lord. My lord, I pray for Passover, my lord, only for today, my lord.
ये पहले डिवीजन बेंच में लगे हुए केसेस है ना, वही है.
Sorry, my lord, I was appeared in a wrong case.
Wrong case?
Yes, my lord, sorry.
Now who is to appear in that case then?
I am appearing in 38, my lord, not in 33. Extremely sorry, my lord, for inconvenience.
Attendance मत करना. 32 में. ये
My lord, pass.
आप पता करिए. Counsel for the petitioner wants time to take instructions listing first week of. Yeah.
Item number 34. Shiv Kumar Vishal.
Withdraw this petition, my lord. Withdraw this petition, my lord. Withdraw this petition, my lord.
I withdraw it. I was not able to understand.
I withdraw this petition, my lord.
It's permission.
Yeah. So you said Lordship withdraw the petition. Counsel for the petitioner prays to withdraw the petition. Dismissed as withdrawn.
Item number 35, Mr. Lakshmi Narayan Das.
Lordship, in this case, the conducting lawyer has died, your lordship.
Who?
Conducting lawyer has died. Sri Lakshmi Narayan Das. Conducting lawyer has died. An opportunity may be given to the petitioner to engage another lawyer.
Well, you are handling his office.
I was, but my wakalatnama is not there, your lordship.
Then you should have asked for send a letter to those people. You can't put it on us. Whoever takes over, this is a regular feature with all lawyers. We have seniors, we have those who are either elevated or elevated otherwise. Well, these things, they are part of the legal system. But whoever takes over, he takes on his shoulders the entire responsibility. You should have written a letter in 2015 matter. What is the case?
Case is related that the payment of the retiral dues and considering the service period of 2000 petitioner for 2005
When
and
did he
6.
retire?
He was not intimated by the respondent authorities with, for his dismissal, your lordship.
When did he retire?
He retired in 2006.
It's a
He was
hard.
dismissed.
Yes,
He has been dismissed,
In
but
fact,
no
it's a
intimation.
He was dismissed in 2006.
But they have
And he
not,
files a petition in 2015.
there is no communication for his dismissal, your lordship, from the respondent side.
Is she there now?
They have not communicated the dismissal order to the petitioner, your lordship.
If that is not communicated, that should have gone elsewhere.
And matter relates to army, Your Lordship. There is a tribunal.
नायक
Army matter.
काम आएगा ही नहीं वो. Dismissed. You can't even otherwise. Under the AFT, it should have gone. After the Armed Forces Tribunal Act has come into force, this what does not lie here. The petitioner assails action of dismissal passed by the armed forces in terms of the Act, Section 14, Armed Forces Act निकालिए 2014 का है 2000 देखिए AFT 2010 है पहले का 2014 2007
वहीं पे बुक
साल पे
वहीं पे
सेंट्रल
उधर होगा कॉन्ग्रेचुअली उधर अल्फाबेटिकली है
AFT this court would have no jurisdiction to decide to entertain a writ petition challenging the dismissal order. Passed under the Army Act.
Army Act 20, Section 23.
तो डिस्चार्ज किया इसका मतलब.
He was declared deserter, and after 10 years he was dismissed. He never joined after.
It's not a case of dismissal. It's a discharge.
He was discharged.
No.
After 10 years.
2007. Notes of Section 14 of the Act of 2007. The application ought to have been filed before the Armed Forces Tribunal, which has not been done. Writ petition is wholly misconceived at this way as not maintainable. Even in 2015 it was not maintainable.
Yes, Item 36. Mr. Shambhu Sharan Singh. 36. Mr. Shambhu Sharan Singh.
The petitioner, by way of this writ petition, has prayed as under. There no one appears. The Mr. Mishra, यहाँ पे आपके पुलिस प्रोटेक्शन केसेस कहाँ जाते हैं? पुलिस प्रोटेक्शन के आते हैं couples? Anyone knows?
Criminal writ.
They file a criminal writ. They go to the for police protection after getting married, then or for protection of their.
File criminal writs.
Because 2015 there was no such concept, so we'll have to send it.
Patna High Court from the very beginning was
Has prayed as under court kar dijiye. The writ petition is essentially for seeking police protection. It has been filed in the year 2015. More than 7 years have lapsed. No one is present to argue to press the petition. Dismissed for non-prosecution.
Item 37, Mr. Rajiv Kumar Singh.
Lord, Annexure 1 at page 15 is the order of District Appellate Authority against which, my Lord, the present writ application has been filed. My Lord, my limited grievance, my Lord, is
District Appellate Authority. Go there.
My Lord, this is
2015.
28/4/2015.
Yes.
Prior to constitution of the State Appellate Authority.
I was looking at the orders passed by the coordinated benches. They have sent it.
My Lord,
And after that, those people have come here.
Lord, I have waited 7 long years, my Lord, and
You
now.
should not have. You should have at that time immediately. You should have moved application, asking for getting it disposed of.
The person, my Lord, who has been appointed.
All right, we will direct. Likhe, in view of the judgment passed by this court in Suresh Ram, this writ petition is held to be not maintainable, with liberty to file an appeal before the District Appellate Authority, State Appellate Authority. Before the State Appellate Authority, challenging the order of the District Appellate Authority. If such an appeal is preferred, the delay in filing the appeal shall be condoned and the same shall be decided on merits expeditiously.
38. Mr. Praveer Kumar Agrawal.
This is pass over 40 day. Argument counsel on leg in another court.
You argue. That is. Yes. It's an old case. He would not be much interested. What is the order which is under challenge?
Additional Collector Madhepura.
Additional Collector Madhepura. What is the order?
My Lord. Lecture 1, page number 15.
Yes. What is the order? What are the contents of the order? What has he done? It has admitted mutation revision.
36/1982 में फैमिली पार्टीशन हो गया था.
So if that mutation revision has been admitted, would not an appeal lie against that order of the collector to the revenue board? What is the order?
The remedy is valid against the mutation order. Appeal will lie before the DCLR, and against the order of DCLR, my lord, appeal will lie before the collector or additional collector.
After that, there is no revision, there is no provision.
Revision lie before the additional collector, my lord.
Additional
Order of
collector-
additional collector is not on record, my lord.
The order has been passed by the additional collector.
No, first order, Annexure 4 is, my lord, order passed by the circular officer. Again,
Upper
Annexure,
Samaharta. Annexure 1. Dakhil Kharij Revision Wad.
oh, yes, sorry.
Dakhil Kharij. What is Dakhil Kharij?
Mutation, my lord.
Mutation.
Oh, sorry, my lord. Extremely. I have examined the Annexure 4, 5. I missed this, my lord, Annexure 1. There is a rule, Act, my lord, Mutation Act 2011.
Mutation Act 2011,
my lord.
Love. That is the complete name or?
No, my lord, complete name, my lord.
What is the complete name?
Bihar Mutation Act 2011.
Bihar Mutation.
Sorry, the Bihar Land Mutation Act 2011. This is the full description, my lord. And Section 7, my lord.
Yes. Land.
Lordship.
Yes.
Lord, Section 7, my lord. Appeal, Chapter 4, Appeal and Revision.
Section?
Section 7, my lord.
Live volume 16 15 और 16 इसके बिहार लोकल लॉज के वॉल्यूम
लैंड म्यूटेशन एक्ट 2011
ये ना इसकी
जी मैडम
इसकी वॉल्यूम 15
जी मैडम
ये 16 है इसके लोकल लॉज लगा दीजिए
लगा दीजिए
So what does it say?
My lord, appeal will lie before the DCLR, my lord, Land Reforms Deputy Collector.
That has been done.
Yes,
After
and
that,
against the order of appeal, my lord, revision will lie before the collector / additional collector, ADM.
That's final.
That is final, my lord.
That is final.
Lordship.
All right. Yes. Tell us now, what is the what is the legality, Mr. Again, of the order passed by revision? Annexure 1 की क्या गलती है? पढ़ो. Have you read it or you want time?
मैंने पेज नंबर 15 दिनांक 10/5/2010 को ध्यानपाल सिंह, शिशुपाल सिंह पिता स्वर्गीय रामचंद्र प्रसाद यादव, उमा देवी पति स्वर्गीय रामचंद्र प्रसाद यादव साइकिल मथुआ, आलम नगर के द्वारा नरेंद्र प्रसाद यादव, विजेंद्र प्रसाद यादव एवं शैलेंद्र प्रसाद यादव साइकिल के विरुद्ध दायर किया गया था, जो दिनांक 30/5/2012 को निष्पादन अपर समर्था मधेपुरा के न्यायालय में हस्तांतरित किया गया।
Mutation is now is entry in the record, no revenue record.
Yes, yes, in register 2.
What right has been taken away? They are all proceedings which
It
for
will
which
not create any title, my lord. It's just.
does not create any title. You file a title suit. Is there a regular suit allowed in the under the revenue law? The revenue suit can be filed, huh? यहाँ भी क्या provision है? I'll have to. Yes, yes, please assist if you can.
My lord, in this in a mutation order, there is 3 forums in the statute. Thereafter, he wrote in the Bihar Land Tribunal, the order passed by the revisional authority has to be challenged before the BLT, my lord, Bihar Land Tribunal.
Yeah.
So my friend has an option to move before there, and thereafter High Court, my lord. Please, my sir. Mutation will come. BLT में हो गया.
BLT बन गया ना? Yes, BLT Act is also.
Bihar Land Tribunal Act.
Yes,
Lord,
yes, yes.
against the final order of the revenue authority, that could be challenged over there, my lord.
My lord, this record transfer.
Admittedly, the order passed by the additional collector Madhepura in revision dated.
My lord, under the Bihar Land Tribunal Act, my lord, 7 Act has been mentioned in the.
नहीं है,
that has been inserted later on.
That is there.
That is
That is there. This is
oh, then there is no problem. The mutation act was inserted later on.
17/1/2017. कब की डेट है इसकी?
Yes, my lord. 7/2017.
Is an order which can be challenged before the Bihar Land Tribunal. 17/1/2015 है. There being an alternate efficacious remedy, statutory remedy available, the writ petition is held to be not maintainable. However, liberty is granted to the petitioner to challenge the order if so advised before the BLT. If such a challenge is made, the case shall be decided on merits, waiving the limitation period.
मैंने सेम रिकॉर्ड को ट्रांसफर कर दिया जाए. हुजूर अर्लियर पहले
High Court writ petitions are never transferred. There is no procedure of transferring writ petition. Writ is an exclusive domain of the High Court.
अनदर को ट्रांसफर
अगर किसी ने किया है तो I can show you a judgment of Supreme Court. It does not cannot be done.
One case, my lord, at serial 36, my lord, that is defect in DFD, my lord.
Item 39.
36, my lord.
क्या हुआ?
That has become DFD, my lord. Dismiss in default of prosecution, my lord. I want to, my lord, withdraw this case, my lord. Serial 36 पर है DFD हो गया, उसको withdraw कर लेना चाहते हैं. Grievance has been redressed, my lord.
हमने तो dismiss in default कर दिया non prosecution में.
उसको हमारे अगेंस्ट होगा. Grievances has been redressed, उसको withdraw कर लेते हैं.
Appearance लिखा देना. Please to withdraw. Dismissed as withdraw. Yes, 39.
Grievance has been redressed.
लिखा दिया.
ठीक.
Item 39, Mr. Aditya Narayan Singh and Mr. Dinesh Kumar Rai.
मिलोट सीनियर आए नहीं अस्वस्थ हैं, एक सप्ताह टाइम. सीनियर आए नहीं है सर, अस्वस्थ हैं.
अरे आप खुद ही हमारे लिए तो बहुत सीनियर है. आप ही बहस कर लीजिए.
फाइल नहीं है सर.
What is the case?
To provide protection to the petitioners so that the petitioner may complete the construction of Sulabh Shauchalaya complex according to the order dated 8/1/2015 passed by Patna High Court in public. Main competent 3 and 5, my lordship. I am appearing on behalf of the state.
It must have already been constructed. This must have already been constructed. This is in 2015.
Dictionary बताएंगे lordship.
नहीं जानते.
सुलभ शौचालय बनाने के लिए मांग रहे थे प्रोटेक्शन.
One week time ago.
You are appearing for the executive engineer.
State lordship.
State means whom?
Number
District magistrate.
District magistrate.
So what are your instructions?
Then to respondent number 5
District
and
Bar
3.
Association Vaishali.
Nagar
You are
Parish-
agreed of the action of District Bar Association.
हम सर.
तो क्या बार एसोसिएशन के पास बना रहे थे? कहाँ बनवा रहे थे? सुलभ शौचालय. The
सिविल कोर्ट के गेट पे
we are disposing of the matter. The petitioner by way of this writ petition has prayed to provide protection to the petitioner so that he may complete the construction of Sulabh Shauchalaya complex in accordance with the directions of this court passed in PIL 11525/2014 dated 8/1/2015. Seven years have elapsed since the filing of this petition. The writ petition has been rendered odious, accordingly dismissed.
Item 40. Shri Chandra Mishra.
In this case, my lord, the reply has already been filed, my lord, as it appears from Annexure B, my lord.
What is the prayer?
Prayer is, my lord, for compassionate appointment, my lord.
Have you?
My lord, your
Have
lordship
you
may kindly have a look, my lord, page
Have
11.
you offered him?
My lord.
He has been given redressed.
My lord.
He was redressed.
Yes.
Let
Last
us
redress-
for the respondent states that the grievance raised in the present petition stands redressed as the petitioner has been offered compassionate appointment. Writ petition accordingly dismissed as having become infructuous.
Item 41. Shiraj Vallabh Prasad Yadav.
Lords, the matter has become infructuous, my lords.
Why?
Because, my lords, this relates to the advertisement of 2014, my lords, and the commission has completed the selection process. The successful candidates have been recommended and appointed, my lords. And moreover, my lords,
No one has been implemented as a.
the commission has filed this counter affidavit also, my lords. In the writ application, it does not appear, my lords, that any private respondent has been.
What does he say? The petitioner, no one appears for the petitioner. This is an application praying for quashing the terms and conditions of educational qualification laid down in the advertisement issued by the respondent Public Service, Bihar Public Service Commission, the year 2014, whereby exemption from passing national elevated test was extended to only those candidates who have obtained PhD degree on the basis of minimum standards and procedure regulations 2009 framed by the UGC. This has already been upheld by Supreme Court.
Yes, in P. Sushila case. And
that is what that citation did.
Yes,
the issue raised in the present petition is no more res integra as stands finally settled by the Supreme Court in P. Sushila versus so and so 2015 Volume 3
PLJ Supreme Court 278. It
PLJ?
has been, yes, it is also reported in PLJ.
You don't cite SCC here?
Milords, we cite
2015.
Supreme Court, SC, within bracket Supreme Court.
Citation did them.
278. And the coordinate bench of this Honorable Court has also been.
And moreover, this court finds that the selection process has already been completed. View thereof, the writ petition is wherein it has been held as under court kar dena. In view thereof above, writ petition is dismissed.
Item was 66.
Milord, this writ petition was filed with 3 grievances, Milord.
Why are you taking it?
Requisite fix.
अभी टाइम ले 15-10 मिनट और 5 मिनट और दो. ऐसी कौन सी अर्जेंसी है?
Item 42, Mr. Ajay Kumar. 42, Mr. Ajay Kumar.
Yes, anything still surviving in this case?
My Lords, as of now, current stage is not aware, Your Lordship. However, the ACP, grant of ACP cannot be provided to the petitioner, my Lords, in light of para 8, 9 and 10. And the pay scale, benefit of pay scale grade 3 has been provided to the petitioner, and we have also annexed the annexure, Your Lordship, which is the last annexure of counter affidavit filed on behalf of.
You say that he is not entitled for ACP?
My Lord, he is not entitled for ACP, reason being he is superannuated in 2007 itself. And that time, Your Lordship, the petitioner appointment was being ruled under Bihar Rajkir Kit Prarambhik Shiksha Pronati Niyamavali 2011. Which got repealed, and he was appointed under my Lord's Elementary School Teachers Promotion Rule 1993, which got repealed, and in 2011, Your Lordship, it came as Bihar Rajkriya Kit Prarambhik Shikshak Pronati Niyamavali 2011, and he superannuated in 2007 itself, Your Lordship. However, Your Lordship, he was granted benefit of grade 2 as he is just matric pass, and he has not completed his graduation.
What is that judgment of full bench which said that under the earlier rules of promotion rules of 93, you will make year-wise promotions?
My Lord, I am specifying, Your Lordship, with that regard, last annexure of our counter affidavit, it speaks, Your Lordship, that grade, if
someone is granted grade 2 pay scale and he's not graduate, then my lord, the grade 3 pay scale has to be granted to him with regard to the appointment which has been made, your lordship, and that the consideration for the same has been put forward to the respondent authorities. And subsequently, your lordship, as per the stand taken in the counter affidavit, the consequential benefit will also be granted. However, lordship, as of now, we are not aware at what stage it has reached, whether the grievance of the petitioner has been redressed or not. Your lordship may grant me 1 week time, I'll find out that as well.
Counsel for the respondent shall file an additional stroke supplementary affidavit informing about the present status with regard to grant of the third selection scale.
My lord, third scale, grade 3 selection scale.
Third. Just after 3 weeks.
Item 43.
Lord, may kindly also direct for consequential benefit as your lordship.
3 weeks. We have got the present status. You just
Your
give the
lordship,
entire
your lordship.
details.
Highly obliged.
Lordship, this matter land of the petitioner was acquired by the state government of Lordship for the construction of Thana Lordship in District Support. Petitioner was aggrieved with the compensation decided by the concerned authorities, Lordship, that is District Land Acquisition Officer Sopal, as the land was purchased by the petitioner as residential, but the nature of the land of the petitioner was decided on the basis of being treated as progressive, and against the said
New Land Acquisition Act.
Yes, Lordship. Right to fair compensation and
Right to fair compensation.
Lordship.
You have named it as New Land Acquisition Act
Actually, Lordship,
2013.
this writ petition was filed in 2015.
We would have been so happy that you had been in Parliament and got this name.
Lordship.
Instead of making it as.
Right, Lordship. But this matter was filed in 2015 and I was not involved in this matter, Lordship.
All right.
In the meantime, the arguing council expired and I have got this Wakalat.
No. What is the position?
So, the position is, Lordship, and have a look at Annexure 7, Lordship.
So if you have been paid less compensation,
yes, Lordship,
then you file appeal for there is a provision of appeal under the.
But actually, Lordship,
I think after that you have to go to the civil court.
No, Lordship, I have not gone to the civil court because there are two grievances of the petition, Lordship. The first, with regard to the nature of the land. Did you take up the objection
before the land acquisition officer?
Lordship, if I permit, Lordship, there is two grievances of the petitioner, Lordship. The first is with the nature of the land of the petitioner. And second is for treating the acquisition of the land under New Land Acquisition Act, Lordship. So there is no provision under Section 64 of the New Land Acquisition Act, because Section 64 says that who is aggrieved with the award prepared under the New Land Acquisition Act, Lordship. The acquisition was of year 2013 and award was prepared in 2015. So as per Section 24(1)(a) of the Land Acquisition or New Land Acquisition Act, Lordship, all benefit with regard to determination of market value will apply under Section 26 of the New Land Acquisition Act, Lordship. But this without direction of this Honorable Court, because there is no provision for filing of a reference application under Section 64 in this type of matter, Lordship. So interference of this Honorable Court is needed, Lordship, and the respondents may be directed to treat the acquisition of the land of the petitioner under the New Land Acquisition Act and determine the market value under the New Land Acquisition Act, Lordship, under Section 26 of the New Land Acquisition Act. Kindly have a look at Annexure 7, Lordship. That is at page 35.
Are you ready?
Lordship, I would like to place para 13 of my counter affidavit.
Are you ready to argue the case?
No, Lordship.
We will finally decide it. Because your counter is there, nothing further is required.
Let me verify.
You also don't want to file anything more.
Lordship, counter affidavit is not available with me, Lordship.
This counter affidavit is not there with you?
No, Lordship. Because
copy of the counter affidavit we made available to the counsel for the petitioner. ये आपके सारे केसेस में आप लिख देते हो एडवोकेट इज नॉट फाउंड
No, Lordship.
आपके लिए नहीं कह रहे इनकी
नहीं इन्हीं का कह रहे हूँ सर कि कहीं कहीं पे बहुत मेरा 4 मैटर और है हुजूर सेम एक्विजिशन से रिलेटेड, वहाँ भी कोई काउंटर एफिडेविट अवेलेबल नहीं है और कौन एडवोकेट है हुजूर ये भी पता नहीं चल रहा है।
इसमें लिख देते हैं सब में, वी आर फाइंडिंग इट इन ऑलमोस्ट ऑल द केसेस। The registry was accepting it. लिखिए, counsel for the respondent shall make available a copy of the counter affidavit to the counsel for the petitioner, who may file a rejoinder if he so chooses. List this case, 3rd week of January.
I think 44. Madhu Kushum.
May please, your lords. My lord, this is through this writ application, my lord, the petitioner just tried to demonstrate that the inaction on the part of assurance made by the state, that the death which has been caused due to the wrong vaccination to the children in the school, the government school, your lordship, and that to your lordship, the respondent authority has said and come with an assurance that they will be adequately compensated.
You have a copy of this as they filed their reply? No.
The counter has not been served upon us, my lord.
Who appears? Issue notice. No one appears. For the government?
For the government, my lord, the learned AG is to be appear, my lord.
In this case, SC.
AG जिनको authorize करेंगे ना?
NK Singh, SC2.
C2 will back.
Authorize करेंगे.
C2 को नहीं है उनके पास, कोई दूसरे कोई और की है, C2 है.
Issue notice. You file and give a copy again.
To the state, my lord.
Issue notice to respondents 6, 5, 6, 7 and 8. Returnable 4 weeks.
Item
50. Yes, so urgent matter लगेगा. Where is that urgent case? Yes, what is the urgency?
My lord, the urgency is that, my lord, the examination is to be conducted. The petitioner had come with 3 grievances, my lord. First was the grant of NOC by the state government, and secondly...
This case came up yesterday.
No, it has, earlier also it was taken up, my lord, and on adjournment, my lord, it has come today, my lord. It was directed to be listed today. My lord, as far as grant of no objection certificate from the state government is concerned, my lord, that has been granted. Now, my lord, the grievance which remains, my lord.
No objection certificate granted, my lord, in favor of the petitioner issued, my lord.
So we pass an order, same order judgment which we have given?
In Sai Baba College, my lord.
You agree?
4198 of 2022.
You have a copy?
My lord, I couldn't get the copy, my lord. I will provide to the court master, my lord, in few moments, my lord.
We direct you to conduct examination and declare the result within a stipulated period of 3 months. All right? Likhiye.
My lord, this point number 5 is the 5, 6 and 7. 7 is to conduct the examination of B farm, my lord. 5 and 6 are the university who are to conduct the examination of B farm.
5, 6 and 7, all three of them. Respondent number 5, 6 and 7 are admittedly the petitioner has already
the university council is
NOC from the state on
On, my lord, 7th of December 2022.
7th of December 2022 with regard to academic session 2021.
Yes.
The petitioner, the students have already completed their course, but the examination has not been conducted by the university solely on the ground that the NOC was not being made available by the state government. Keeping in view that the state government has already granted NOC and also considering the it is now directed that the university shall take immediate steps to conduct the examinations of the students in terms of Section 31 of the Universities Act and declare the result within the stipulated period. The entire exercise should positively be completed within period of 4 months from today. It is made clear that the order shall apply both for B Pharma as well as D Pharma.
D Pharma is to be conducted by Controller of Examination Health Services, my lord. It is separate
D
body.
Pharma courses. The concerned stakeholders, which include the state government, bracket में कर दिए, for the purpose of D Pharma course, would be governed by the aforesaid order. Writ petition is allowed in aforesaid term. Any other update? There was 126. What was that?
Batch case.
That batch case.
Item 126. Mr. Purushottam Kumar Jha.
ये साई कॉलेज का भी तो केस लग रहा है 67 नंबर पे. Where is that? Who is in that case? सुमन कुमार. ये कल लगा. Who has got this case marked as urgent?
Mr. Purushottam Kumar Jha.
ये खबर साई कॉलेज है.
Shaiba. Sure.
Where is Mr. Suman Kumar? Item लगाओ.
67. Mr. Shuman Kumar.
नोट करिए. उस पे आ रहा है क्या?
जी नहीं,
उस पे करो. Mr.
मेंशन किए तो 126 वाला.
मुझे आगे रहने. ये केस लगाइए वापस. ये जो कॉलेज के हैं ना these matters.
जी मैडम.
65. ये 64, 65.
जी मैडम.
ये सब मैटर्स लगाइए फर्स्ट.
जी मैडम.
यहाँ से 62 से सो मोटो भी है.
जी मैडम. शो मोटो.
ये 62 में कौन आया? Anyone appearing in 62? ये should be mentioned category में डालिए.
जी.
To be mentioned category में 62,
62,
63 से लेकर 68 तक की.
जी मैडम.
These are all matters relating to examinations.
Tomorrow.
कल लगाइए.
जी.
We'll take them up tomorrow.
That is also.
Lordship, item number 32, Lordship, when the case was called, I could not appear since I was coming. In the meantime, the case has been passed over, giving that no one appears on behalf of a state, Lordship. I am appearing, my counter has been filed, Lordship, in the item number 32, Lordship.
No, now you are appearing. That time you are not appearing.
Lordship, at that relevant time.
We have to say that at that particular time.
Lordship. No,
You know it is a live streaming. Everything is recorded.
Lordship.
So how can no I say that no you were appearing that time? I can't.
Lordship.
Gone is gone. Bygones are gone. It's all your demand that we are doing live streaming.
Yes.
Yes. What do you have to say?
My Lord, on merits, the appellant's prayer for bail of the earlier rejected, Lordship. So only the period of custody is the present ground, Lordship. And
He's been there now almost.
My Lord, about 7 years.
More than 7 years.
More than 7 years, Lordship.
And more than 8 years.
Lord?
More than 8 years.
More than 8 years, Lord. 8 years.
22/4/2014.
14. My Lord.
Yes.
My Lord, more than.
It's more than 8 years?
More than 8 years.
8 years and 8 months.
8 months. My Lord.
And what about the paper book? Have you tried?
No, my Lord. They have not supplied me paper book, my Lord. Neither paper book is ready, Lordship.
I have not informed, my Lord. Neither the case has been listed for hearing. No, neither the case has been listed for hearing, my Lord. So that, my Lord.
Sharma, even if we direct for listing for hearing, it will not be immediately.
I'm not saying that. Just my Lord has asked that whether the paper book is ready or not. That is what. That is why I replied that the paper book is ready. And
Learned counsel appearing for the accused petitioner submits that on 24/8/2017 he was granted liberty to renew prayer for bail.
My Lord.
If the appeal is not taken up for final hearing within 1 year. Stop. Learned counsel submits that the accused has remained in custody since 2nd April 2014 and more than 8 years and 8 years. 8 years and 8 months have gone by and the appeal could not be taken up for hearing, and there are no chances of the appeal being taken up for hearing in near future too. He therefore prays for suspending the sentence at this stage. We have considered the submission and taking into consideration the long period of petitioner being in jail and the appeal being not taken up for hearing and chances of the same to be taken up in near future are also bleak. We are inclined to grant bail to the petitioner, 20,000 surety of lack of life.
Item number 6, Dr. Rajesh Kumar.
May I please, Lordship? Conviction, my Lord, 304B of the Penal Code, life imprisonment, my Lord. On merits, his prayer was earlier rejected by order dated 21st of August 17, my Lord. And by now, he has completed 8 years in judicial custody. That is to say, from 12/9/14, he is in jail.
14.
Written objection करना पड़ेगा. Written objection by the estate has been filed, my Lord.
These are the objections. Right. At least 10 years to keep it. As the Supreme Court has given it. You cannot try and get the hearing done. But in this case, in spite of this other being passed into still was it listed in hearing?
No, my lord, not at all. Though 17, the coordinate bench of your lordships, of which Honorable Justice Prasad was party, has directed to prepare the paper book. Yet not prepared, not listed.
Yes, please, sir.
My lord.
Paper
book is ready. Paper book is only ready. Matter is not listed for hearing.
Yes, Lord. Lord, as per evidence, Lord, the appellant used to demand, my Lord.
That's another aspect. That question is that in 2017, directors were to list this case for hearing per seriatim. Paper book was also required to be prepared.
And the paper book is ready.
It was never listed for hearing.
No, my lord. Since it was written that by seriatim.
Since when is he in?
Pardon, my lord.
Since when is he in jail?
8 years, my lord.
Exact date?
A statement I have given.
September 2014.
Yes, my lord.
What's the date?
12/9/14, my lord.
12/9.
12/9/14. More than 8 years, my lord, now.
Yes. You have to say anything else?
On merits, my Lord, the prayer for bail was earlier rejected by this honorable court.
Lord Sitting Council appearing for the petitioner submits that the petitioner is in jail since 12th of September 2014 and the case has not been listed for hearing in spite of the directions of this court while rejecting the earlier bail application dated 21/8/2017. Although the paper book has been prepared as stated by the learned PP, this court finds that there is no likelihood of the case being taken up for hearing in near future, and the accused petitioner has been in jail for almost
more than 8 years.
More than 8 years. Without going into the merits of the case, considering the long incarceration of the petitioner, we are inclined to release the petitioner on bail, subject to submitting bail bond, 50,000, and surety of liability.
Yes, on fine also. Fine be also stated.
Item number 7.
The sentence of fine. वो स्टे करेंगे जमा कराएंगे
किए नहीं अभी तक
जमा नहीं करे आप फाइन
8 साल से जेल में निकल के खाना मिलेगा कि नहीं, इसको अब तो कहाँ फाइन जमा करेगा, कौन है देखने वाला?
The entire family is there. Your others have been left out. We were seeing the facts of the case, Mr. Shah.
8 साल में तो फैमिली मेंबर का चेहरा भूल जाता है आदमी.
जब सब नहीं किया है
भी डाउट आया था
तो Baki, he has been only
My lord is
section
perfect.
304B.
I share my lord's feeling, but that can be a stayed for the moment.
It's only
Hearing mein
because
dekha-
it's
hearing-
only because otherwise on merits.
True, my lord. True, my lord. No, merit also the earlier order, if my lord will see,
Don't
they will
check.
get.
Item number 7, Mr. Shakil Ahmad Khan.
May please. The conviction is, my lord, under section 300/34 and 201, my lord. Earlier, at the time of admission, after receipt of record, the bail application, bail was prayed but not it was pressed. Last page, at page 15, my lord, order dated 21/8/17. Bail was earlier not pressed, my lord, in this appeal. And thereafter only this present IA, 1 of 2019 has been filed, which is being heard. In this case, my lord, the appellant is in jail for 8 years and 6 months or more. He is in jail since 2014. This case, my lord, no eyewitness, no direct evidence.
There are 2 eyewitnesses,
No, they are, my lord,
PW9 and PW10.
they are, my lord, supposed to be an eyewitness, but actually during cross-examination, they had
In cross-examination, they have stated,
demolished, my lord. And the
they
informant,
deposed that you have burnt their mother. Why should they depose against you otherwise?
that's true. At the
So very
time of,
heinous
at the time of, my lord, occurrence,
offense.
at the time of occurrence, those 2 witnesses were with the grandmaternal father, my lord. And under their influence, my lord, because the father of the women was the informant, and under his and the, my lord, after 28 years of marriage.
Is the paper book ready, Mr. P.T.?
Paper book is not ready.
नो चांस मिलॉर्ड अपील आजकल हुजूर 14 का अपील रेगुलर वे में सुनवाई हो रहा है 2014 का अपील रेगुलर वे में सुनवाई हो रही है और ये 17 का अपील है
नहीं तो यहाँ पे जितनी ज्यादा सेंटेंस हो उसके हिसाब से नहीं है उस लाइन में भी बहुत नीचे चला गया सब हमारे 8-9 साल तो सब वो बताएगा
And my lord may kindly see the one paragraph of finding law.
21.8.
After 28 years of marriage, the mother of 7 children, 5 sons, 2 daughters, she committed suicide. Because, my lord, the daughter was marriageable age and she was insisting for managing money to this with her husband, the appellant. He could not manage the for marriage of the girl and therefore committed suicide. On the day of occurrence, the appellant was not at their house. And earlier, my lord, daughters were sent to Nanihal by the deceased purposely and she committed suicide. I am, my lord, reading, my lord, paragraph 28 of the judgment at page 12. उभय पक्षों के बहस के आधार पर और अभिलेख पर उपलब्ध तथ्यपरक साक्ष्यों एवं साक्षियों के साथ परिशीलन आवश्यक हो गया है। सभी अनऑफिशियल साक्षियों के साक्ष्य में बचाव पक्ष द्वारा बचाव किया गया है कि आवेदा खातून लड़कियों की शादी के लिए पैसा जुटाने का दबाव मोहम्मद साबिर को देती थी, मगर मोहम्मद साबिर पैसा नहीं जुटा पा रहा था। इसी गुस्से में आवेदा खातून ने आत्महत्या कर ली, अर्थात आवेदा की हत्या एक स्वीकृत तथ्य हो जाती है। तात्पर्य यह है कि चाहे उसने आत्महत्या कर ली, चाहे साबिर ने मार डाला, अगर अप्राकृतिक मृत्यु होना एक स्वीकृत तथ्य हो गया है। यहीं पर उल्लेखनीय है कि यदि आवेदा खातून ने आत्महत्या की तो क्या आत्महत्या के बाद अपना दोनों पैर घुटने के ऊपर से काट लेगा? At best, my lord, and this presumptive evidence of 304B has been applied in this case, though it is a case of 302. No direct evidence, my lord. And it is presumed because her dead body was found in the house, and no substantive evidence, my lord, and presumptive evidence is not applicable in 302 case, my lord, and 304 case, more than 8 years and 6 months, my lord.
Yes, PP sir.
This is the case of brutal murder of the deceased, my lord, as per post-mortem report.
Who has identified the corpus? No. Has there been identification of the corpus?
So far, my lord,
Complete burnt,
What is this trial?
not identifiable.
Huh? The dead body which was recovered from the river.
But, my lord, on the basis
Has anybody identified it to be that of the deceased?
Lord, on the basis of the inquest report, my lord, the body was.
Then yes, the inquest report, there must be witnesses.
Inquest report was prepared by the IU, my lord.
The IU doesn't prepare it on his own. He will not get his. How can he dream it that yes, this body belongs to so and so? Somebody should have identified the corpus.
Because the moment I myself done this trial, उसमें बॉडी उसने nobody else identified.
Two persons have identified the my lord, were signed on the inquest report, my lord.
Were they witnesses?
Wajid Ali and
Were they
Mohammed.
brought as witnesses in the court? Are they?
मुझे पता था कि आइडेंटिफाई
Wajid Ali and Mohammed Azhar. They have not been examined.
Yes. They have not been examined.
They have not been examined.
Sorry, ma'am. Yes, PW13 is Muhammad Ahmed, the witness to the inquest report. PW13, ma'am.
Muhammad Amjad.
I think इनको प्रूव करना
Plus these two PW9 and 10 also. They have stated that in cross-examination. Page 7.
Regarding his evidence, the judgment paragraph 20, it has been dealt that he belongs to the village of the informant, mother of the deceased, father of the deceased, and both evidence is similar. They got information that the deceased has been killed. On information they reached there, and dead body was so burnt that it was not identifiable. At best, my lord, the appellant may be responsible for 201 by 34, my lord. And for that, my lord, because it is natural, my lord, if dead body is found and the responsible person comes, they will want to dispose of the body, my lord. And besides that, my lord, there is nothing substantive.
Yeah. Heard learned counsel petitioner as well as learned PP. The accused petitioner is in jail since 2nd June 2014. The allegation is of having murdered his wife by burning her alive. On having considered the statement of PW 9 and PW 10, and also having considered the fact that the corpus recovered was not identified to be that of the deceased wife of the accused, we are inclined to release the petitioner on bail and suspend the sentence. 20,000 surety of life.
Fine is
Sentence suspended. Sentence includes everything.
Item 8, Mr. Jitendra Singh.
What did you want to say something?
I don't know.
Huh?
It looked like he was dazed.
Or you wanted to say something? He was dazed, but why it is in so short words? The headline is from my feet. The judgment and order should pass as contained. Proceed.
My lord. Earlier, my lord, by order dated 14/9/2017, your lordship has given liberty to appellant number 2 convicts, my lord. This appellant and his wife Lalmati to renew parole after 7 months if appeal is not likely taken up for final hearing. Thereafter, appellant number 2 Lalmati filed her bail application that was allowed on 5/2/2020. Now, my lord, the appellant, so far the appellant is concerned, the informant, PW 10, at page 7, para 12, he has not supported the case. तीन चार लाइन जो at that time he was breathing. He was found Thagya Devi, wife of accused Jodha Mato, lying on the ground. He was also cut. He did not see by whom they were cut. He also did not see the weapons. Besides, my lord, Parvyan, formal FIR, inquest were not formally proved, my lord. According to FIR, one Ramchandra Mahato, he has raised halla that someone has cut the deceased. He has withheld by the prosecution for the reason best known to them. He has not examined. And FIR attesting witness Sarad Mahato also not examined. They are planned about to complete 7 years, 3 months less, 6 साल 9 महीना.
Husband, wife, no matter what. No election.
I don't mind.
You want to press it?
The other witnesses are also hostile or not supported the case. Main informant has not supported the case. PW9 has come forward to support the case, who is brother-in-law of the deceased, my lord. Only one witness. And who is a resident of another village. Since 17, my lord, 4 or 5 years elapsed. There is no likelihood that the appeal will be heard in near future. Therefore, the appellant prayed.
What about PW8 and 9?
Pardon, my lord?
PW8 and PW9?
He is not eyewitness. Jakar Chaudhary came after the occurrence. PW9 only came forward.
We will examine it at the stage of hearing. Double. Licky. The learned counsel prays for suspension of sentence of the accused. Rameshwar Mahato. While this court had granted bail to the other co-accused, Lalmati Devi, it finds that there are sufficient grounds for not extending bail to the petitioner in view of the statement of the informant as well as of PW8 and PW9. Considering that there has been a gruesome murder of husband and wife, and the weapon used was handed over to the petitioner, accused by the lady. We are not inclined to dismissed.
हियरिंग हुजूर एक्सपेडाइट करा देते।
Expedite hearing.
Item number 10.
In this case, my lord, the written objection has been prepared, my lord, today, my lord. So this case may be kindly passed over for the due. In next week, my lord.
It is raised for time to file written objections. List again, next week.
Mine.
Item number 11.
Lords, केस में kindly be passed हो चुकी एविडेंस नहीं देख पाए हम जी। नेक्स्ट वीक जी, नेक्स्ट वीक में करेंगे।
Item number 12. Mr. Ravi Ranjan. Item number 12, Mr. Ravi Ranjan.
आगे
There is a direction for filing written objection.
Written objections file कर दिया आपने?
The written objection has been filed, my lord, today itself, my lord. So, my lord, this case may be taken up in next week.
Objections have been filed today. List again next week.
Item number 13, Mr. Vijay Kumar Singh.
Not application for bail. Offence for which I have been found guilty, my lord, we, my lord, is 302 by 149. Whereas the sentence has been awarded under section 302.
आपने written objection file कर दिए क्या?
Earlier, my lord, my prayer for bail was rejected at the time of admission itself.
The objections were already there?
No.
Have you filed your written objections? No, we have.
I have not filed.
Prayer for bail at that stage was considered. One person was granted bail and two were given liberty, my lord, who are before my lord, to renew it after 6 months, 8 months. The order I have an explanation.
We give them time to file written objection.
We are already amended. 16/5/2018.
Lord, the application was filed in year.
You were granted time to file written objections on 16/5/2018.
Yes.
2 weeks, my lord.
Do you want to? Otherwise, we can hear it on marriage.
On merits, my lord, in this case, my lord.
Lord, matter relates to the land dispute. As I have said earlier, my lord, the conviction is under section 302 by 149 of major conviction, my lord. Whereas the sentence is under section 302 by 34. That is one mistake, my lord, which my lord made. Lord, in a land dispute, my lord, it is said that one Paltu, my lord, is the deceased. He was given a khanti blow, sharp cutting instrument, my lord, blow on the head by one Tufani being, not these appellants. Not mainly, I will place the post-mortem report also and the medical evidence. That will indicate that that was the only cause of death. So far as this appellant is concerned, one Mohan Bean, about his son, Lord, there is absolutely no allegation, seven, except that he was a member of the mob. Lord, so far as Mohan Bean is concerned, he is supposed to have assaulted the deceased on thigh, causing a bruise only, Lord. My Lord may kindly see the medical evidence. And that is no way responsible for the death. The doctor is of the definite opinion that the death was caused due to the injury on the head, which was definitely given by one Tufan. And by an extra one, Lord.
You have been shown to be the assailants.
I have
You are
assault.
all assailants, na?
I'm,
147 will apply. वो तो लगेगा सबके ऊपर है इंटेंशन तो एक पर्टिकुलर
my lord,
injury it's not a free fight where you can say that one injury will be to one person and the other one to other.
There must be some cumulative effect. Lord, it was a case and counter case over land dispute. And
What?
then, Lord, my lord, if my lord will kindly turn to the medical evidence, Lord, that your lordship will find, Lord, at paragraph 6. वही नेक्स्ट वन में वही ऑर्डर लगा हुआ है वही निकालना चाहते हैं and by annexure 1 Lord I was given liberty to renew it after 8 months यही ना और कुछ Paragraph 6, Lord, your lordship will get the medical evidence. And the final finding, Lord, of the court, Lord, is also there, that it is only the Tufani who has given a khanti blow which resulted in death. So far as assault by us is concerned, it doesn't find place at all in the first information report. It has been developed in evidence.
$149 147, 147. तो सही है ये show the injuries.
Lord, paragraph 6.
There is a bruise on the left thigh.
Yes, that is the only thing. That may be due to fall, that may be due to anything, Lord, and it has not been attributed to me in the first information report. It has been developed in evidence.
Your presence is there.
For that, Lord, I have been found guilty under section 149, and the sentence is.
अरे आएंगे नहीं एक मीटिंग टुगेदर लेते नहीं कॉमन लगाते इनको पसंद मैं सब कर लेते
Now, Lord, my Lord will take into consideration two things. One, Lord, that I am in custody since 7/6/17. In spite of the order of this court, Lord, paper book is not ready and is not likely to be taken up in the near future. Number one. Number two, your Lordship will find that earlier, Lord, I was given liberty to renew it after 8 months. I filed it in 2018, and now we are arguing this matter in 2022. There is no criminal history. They are innocent villagers, Lord. They unnecessarily quarreled, Lord, over a land dispute. There was panchayati also and everything.
Both parties are there.
Both are agonists.
Both?
Agnes. Just for making a cattle trade, my lord, the occurrence has taken place. We also have sustained injury. Charge sheet was submitted under section 307, 149 against them also. That was huh? The defense version, lord, is on record in the form of Exhibit A. And specific allegation, lord, has been leveled against Tufani. Lord, the finding of the court also is like that. Lord, if my lord will permit me, I will place only 2 lines.
Mr. Counsel, that there is already a view taken by the coordinate bench earlier.
Yes, I have annexed 1,
merits.
Annexed 1 I have annexed with my petition.
On merits it is...
On Lord, your lordship will
while Lavangi was
granted bail.
At that stage,
yes,
we have already said, considering the nature of evidence available on the court against appellants 1 and 3, so Mohan bin and Ram Pravesh bin, we are not inclined to direct release of this. Yes. So the evidence was already examined at that stage. Now you can't be asking us to...
And then Lord, my lord will kindly see the liberty.
The liberty is all right.
Yes. Lord, it's a hard time, Lord, only for causing a bruise, at the best we can say.
See, the liberty, you know, with the period of that time when these orders were passed in 2017, yes, nobody thought about this COVID. As a matter of fact, for about 1.5 years, there has been a complete...
No, Lord, we filed our application in 2018, just after the expiry of that
year. Yeah, but that...
It is unfortunate not that it is being taken up today. Considering all these things, Lord, I pray. I'm not the main assistant. The main assistant is in custody.
No, it's in 2017 is there, it's not in 5 years.
And Lord, the main person, Lord Tufani, is in custody. The main person who has pierced the khanti in the head is in custody.
All right. We'll stay together.
Lord, there is absolutely no criminal history, nothing of the kind. And your lordship will kindly see the specific direction of this court.
We are considering that. Yes. The second bail application has been moved in view of the observations made by this court earlier on 21/8/2017, allowing the accused petitioners to renew prayer for bail if the appeal itself is not taken up for final hearing within 7 months. The Learned Counsel submits that the appeal could not be taken up for hearing, and there is no likelihood of the appeal being taken up in near future too. And the accused Mohan bin.
Yes, yes, Mohan bin.
You are only pressing for Mohan bin, na?
No, Mohan and Ram Pravesh, both they are father and son.
The accused.
So far as Ram Pravesh is concerned, Lord, your lordship will not get even a single word.
Accused one is Mohan bin and Ram Pravesh bin be it is argued that the evidence as against Mohan bin is only of causing blow by lathi at the thigh.
At the thigh, Lord?
Whereas the injury is bruise.
Yes.
As per the medical report.
Medical report.
And
so far as Ram Pravesh is concerned, there is absolutely nothing.
There is no evidence of causing any injury by Ram Pravesh bin. It is further submitted that both of them are in jail since
7/6/2000.
7/6/2017.
17. During trial, my lord, they were on bail all along.
And both of them were on bail during trial.
There is no allegation of any misuse, etc.
We have considered the submission and heard learned PP. However, this court finds that the question with regard the bail application of the accused petitioners was examined on merits earlier by this court while rejecting their bail while order dated 21/8/2017 and review as such is not permissible in criminal law.
Not then that observation becomes meaningless.
You've seen that judgment where even sentence rejection after the bail was granted and cancellation of bail. They said that the same court cannot, it would amount to review.
Not, but not in
And the
many,
bar under 162 would apply.
we had been found and that is there. Therefore, Lord, and one thing my Lord will kindly see.
The EP is directed to prepare the paper book.
Yes, paper book has not been prepared.
Is directed to prepare the paper book and the early the hearing is expedited.
Lord, so far as Ram Pravesh is concerned, there is absolutely nothing.
मेरिट्स भी कैसे नहीं एग्जामिन कर सकते unless there is a change, unless there is a change circumstance.
तो यही करते हैं, we don't find any change.
बस कर देंगे बाद में.
Lord, so far as Ram Pravesh is concerned, my Lord will find that
that you should have pressed at that stage, not now.
No, Lord, considering those things, Lord, I was given observation.
My brother was a member of the we can't be reviewing our own thinking, changing our view again on evidence. Once we say that on evidence we have examined your case.
Lord, consideration, Lord, after 6 months or 7 months, whatever that may be, means, Lord, reconsideration in by humble submission. And therefore,
if you had remained like we are doing in cases where the person has been in jail for long without going into the merits, that is the idea.
Yes.
The second bail application, for the reason that if a person has been in jail for quite a long time, then he may move a second bail application after say 6 months, 8 months or anything. But not for reviewing on merits.
No,
if we start re-examining on merits,
my Lord will
then it would be, opening almost in all case, it would be a second opinion if there is a change of bench. If that is allowed, then we will be in a very big situation.
My Lord will kindly visualize the situation that when my prayer for bail
the only thing was there. You should have challenged it there.
Yes, I'm not on merits. I'm not on merits that way, Lord.
And from there, if there would have been a direction that you'd re-examine it, we would have examined.
What I humbly submit is this, that at that time, Lord, it was year 2018. We are, Lord,
you get us an order from there, we will re-examine it.
But at least, Lord, I have got that order that you renew after 8 months. Lord, at that time it was 2000.
Prayer for bail renewal can be done, but re-examining on evidence.
No, I don't say.
That is what you are asking us.
I just placed the merits, Lord, on the basis of which, Lord, and considering that merits, that observation was given. Considering that merits, my Lord will kindly.
The observation is because if the appeal is not heard, say because of delay,
yes,
and you are lying in jail, then we may consider it on that aspect.
Lord,
but 5 years, we have people who are there. You try it.
Lord, I had been
come after some time.
I had been in jail in spite of direction of my Lord's Lord. The paperwork is not ready, and appeal is not likely to be taken up for another 5 years.
They have directed now.
Then
try it on a.
Some time may be fixed, but at least my lord's order should be honored. My lord has ordered preparation of paper book.
All right, we can haul them on in contempt, but that cannot be a ground to grant you bail.
No, I don't
So that's
say,
it.
But we have got every respect, Lord, and it is our
Yes,
duty.
we can understand.
It is our duty to respect my lord's order.
We can
and
understand.
To see that it is respected.
Yes, we also understand that person should not remain in jail. His appeal should be heard on merits.
Yes.
Yes.
Yes. Earlier judgments, Lord, on Rajbatha case and other cases used to say, Lord, that even after 1 year, if you are not in a position to take up the appeal, you must grant bail.
वो सब जमाना था, क्रिमिनल अपीलें अब कितनी आ रही हैं. After all, it's all human being. We are all, you know it. And then the lawyers are not ready to argue cases on merits. That is also the situation.
One way we are fortunate that we have the number of honorable judges, Lord, have increased by 1.5
that is,
times.
That's so.
That is good. And Lord, now the appeal has started, Lord, moving, Lord, with its speed. Therefore, Lord, I requested.
We should comply with the earlier order.
Then we have directed him to file a paper book. No. We have directed him to positively prepare.
Lord, lastly, may I make one prayer? Lord, some time may be fixed, either for hearing of the appeal or for renewing my prayer. I will renew it only on the ground of period of detention.
Last partly, immediately on preparation of the paper book, the registry is directed to place this appeal in the hearing category before the bench hearing the cases.
Item 14. Mr. Rajendra Prasad.
May I please note? Earlier notes by order dated 13/9/17 notes. The prayer for the bill of the appellant has been rejected. The allegation against appellant notes of causing injury to the deceased notes with lathi. Whereas the doctor did not find any such injury notes on the person of the deceased notes. The injury report of the doctor notes has been discussed in paragraph number 17 of the judgment notes. The injuries are inside notes, and the said injury is attributable against co-accused Lakhan Besra Milot.
Since when is he in jail?
He is in jail Milot since about 8 years Milot.
Sorry. Lathi blow ka hai.
Yes, PP sir.
The specific overt act has attributed against this appellant that he also assaulted the deceased by lathi on the head of.
Where is that injury of lathi?
The injury number 1, Mara.
Is of what?
Incised wound.
Incised wound is not caused by lathi. That's a lacerated wound always. Incised wound will be with a sharp weapon. That is by Kudal. That is attributed to this other co-accused.
2 injuries have been.
Yes, what is the other injury?
Both injuries are incised.
Then, likhe. The learned counsel for the petitioner has submitted that the petitioner has accused petitioner in jail since
about 8 years.
Give us a date out from.
He remained 3 years before during trial and 5 years.
You can't be presuming like this. Yes, PP sir, since when is he in jail?
बेल पर नहीं बैठे हैं।
हाँ, 2.5 साल हम लगभग जेल में रहे ट्रायल में।
ठीक।
आपके पास अरेस्ट मेमो होगा ना?
Custody for 3 years. वही तो तभी तो मेरे को लगा ना 17 से तो 2014 का तो हो गया डेट आ जाता पता नहीं because the incident is of 2001 so he must have been arrested then. मुझे तो देखा केस है 100%. इसको इंक्लूड ही बाद में किया है 2013 में इसको इंक्लूड किया लाइए सब देख के हम बता दें चालान पेश हुआ होगा ना चार्जशीट में होगा
गिरफ्तारी वारंट तो जारी करने के संबंध
गिरफ्तारी वारंट से नहीं हुआ सर अरेस्ट मेमो एग्जिबिट होगा ना
अरेस्ट मेमो एग्जिबिट नहीं है सर
यानी 27 की डॉक्यूमेंट भी नहीं पेश वो था क्या नाम है उसका
जोहेन सोरेन
लखन बसेरा के बारे में आ रहा है बसेरा तो मेंटल दूसरा था ना लखन बसेरा तो पागल था ये तो आपने डॉक्यूमेंट जो दिए हैं वो लखन बसेरा के दिए लखन बसेरा इज मेंटल हॉस्पिटल ये पास ऑन कर दीजिए विल चेक इट आप दीजिए फाइल नहीं अभी दीजिए रिकॉर्ड दीजिए
पेपर बुक भी रेडी पेपर बुक रेडी
This was Mr. Thompson, he should have brought. When?
He said 3 years, 9 months.
3 years, 9 months. Huh? At that time.
I just saw it.
पिटिशन नहीं है कोई
9 साल हो गया.
This is a statement, 2018.
कैसे पेश की जाती है.
June 14, it should be somewhere around June 14. June 14.
June?
May or June 14, because it says 3 years, 9 months, and 18.
घटना कब की है
This will be recorded in your records.
ये चार्जशीट है.
रिपोर्ट में तो रिकॉर्डिंग होगा, सरेंडर टू एथिक्स से चल.
कब अरेस्ट किया, कुछ नहीं लिखते हैं. हिरासत में
न्यायिक हिरासत में
2000 ये तो शीट है. 2000 he has been arrested. For how many years he has been in jail? You don't know since how many years he is in jail? From the charge sheet, it seems that he was arrested in 2000.
इस वक्त मेरे पास एक कभी देख रहे हैं.
When was he granted bail? That also is not known. The form of the position only. अंदर चार अरेस्ट किया.
We have done that on 5/12/2002. So 2 years at that time.
Yes. And judgment is of
2 years.
17. 6/7/2000. Judgment is of what date?
Judgment you would have
6/7/17.
6th July 2017. Sixth conviction date is 6th July 2017 and the order of sentence is dated also 6/7.
डेढ़ साल नहीं 2.5 साल तो ये हो गया
इसके बाद इसने मूव किया तब तक इसलिए by the time he has filed this 18 he has said 3 years 9 months. Yes, we correct.
ठीक है. The petitioner is in jail since for more than 8 years, 8.5 years. Looking into the allegation against him of having caused lathi blow, whereas from the perusal of the post-mortem report, both the injuries are of incised wound. We are inclined to going to the merits of the case, we are inclined to suspend sentence. 20,000 surety of liable. ये तो लेके आया करो कि कितना टाइम से कौन जेल में. That is been ये नीचे पेपर को वापस दे.
वहाँ क्या है, वहाँ तो एक चार्जशीट बनती है पूरा उसमें पूरा डेट और 161 के जितने बयान होते हैं वो स्टेटमेंट एक के बाद एक लगते हैं. मैंने 3 दिन अरेस्ट हुआ वो सबके लगते हैं. कोई रिकवरी 27 में तो 27 की रिकवरी लगती है. तो भगवान पुलिस को नहीं आता है इंडिया.
Next.
Item number 15, Mr. Ram Adya Singh.
My lord, please. My lord, the appellant has been convicted by the London Court below, my lord, under section 304B and 34 of IPC. My lord, the 3 accused were there, my lord. 3 persons convicted, my lord. And the appellant is the number 1, my lord. Is the husband of the deceased, my lord. And he is in custody, my lord, since 7.5 years, my lord. Already undergone more than 50% life increase. The judgment has paid.
They were not on bail during trial?
My lord, never, my lord, from the date of. And my lord, the para 28 of the judgment, my lord.
Okay. 810.
दोष सिद्धि में के विद्वान अधिवक्ता द्वारा निवेदन है परिवार से पढ़े लिखे नहीं है तथा मृतका के प्रति इमरान अंसारी प्रारंभ से ही इस विवाद में कारण बंद है, अतः दोष सिद्धि की सामाजिक आर्थिक स्थिति को देखते हुए कम दंड दिया जाएगा। माय लॉर्ड, so far merit of the case is, my lord.
So you are pressing bail for whom?
For one, my lord. One, my lord. Two already.
Which two were released?
Father-in-law and mother-in-law, my lord.
In criminal appeal 810?
My lord, my appeal admitted, my lord, that is annexure 1, my lord, page 13.
The order of 3/10/2017 is the last order?
My lord, 3/10/17 is the last one.
Please read the order. It says that we are not in.
My lord, I am not pressing that order because I never pressed for bail earlier, my lord. That was not pressed. That was pressed for the other two, my lord.
And that was rejected.
That too, my lord, did not renew their bail, my lord, after 6 months. They undergone full period, my lord. And thereafter released.
They have been released.
My lord. And so far, my lord, the petitioner, this appellant is concerned, my lord. This appeal was admitted on 1st August 17, my lord. That is in Annexure 1, page 13. Annexure 1, page 13 of my application, my lord.
You are appearing for Imran Ansari.
My lord. Annexure 1, page 8. Husband. The conviction order, my lord, at last page, my lord, इमरान अंसारी को 3 and 4B के अंतर्गत आजीवन कारावास की सजा।
But if they have, both of them have served their sentence, so far as it is identical against all three of them.
My lord,
all three are similarly placed.
My lord, I
so you also serve the entire sentence.
My lord, I bow down for the lordship, my lord, but due to lack of knowledge, my lord, but otherwise they should have renewed for their after 6 months, my lord. It was the judicial order, my lord. लोग नहीं आए, my lord, नहीं किए. अगर आते तो my lord के यहाँ कुछ न कुछ consideration होता, वो आया ही नहीं. They were having no knowledge, my lord, of the इस 6 महीने के बाद आपको renew करना है, और उन्होंने बिता दिया. All of a sudden they came before me, my lord, that he has also undergone 7.5 years, 8 years, my lord. Then my lord will see, my lord, the merit of the case. The informant herself has stated that she is PW5, my lord. She herself has stated no dowry demand. No dowry demand, my lord. So PW5 may kindly see, my lord. The statement of PW5 is the informant, my lord. That is the mother of the deceased, my lord. She herself has stated that दलाला मेरे यहाँ आती थी, अपने सास ससुर के खिलाफ कोई शिकायत नहीं करती थी. And on the date of occurrence, my lord, he was not at the home, my lord.
Two of them. And their appeal becoming fractured.
They choose to accept the sentence without objection.
No, that is one part. The appeal has become fractured. And they will not press for their appeal. The conviction has at least all three of them.
They will not be fractured because otherwise it will be a stigma. They can get rid of this stigma.
Then either they should be pressing it.
अपील पेश करेंगे, नहीं है तो डिसमिसल होगा.
तीनों ने मिलकर बताया.
The statement of PW5, the informant's mother, informant herself is very important, madam. She herself is stated no dowry demand and मेरी बेटी कैसे मरी नहीं कह सकती. एंड शी हर्सेल्फ स्टेटेड माय लॉर्ड कि मेरे सास ससुर से कोई शिकायत नहीं करती थी.
Consider on marriage too.
It is open to be considered.
इसमें कोई were you given opportunity to file your objections?
No, my
No, Lord. Huh? So you file your objections. You take it up next week.
कॉम्प्लीमेंट की दिया मेरे पास नहीं है पहले असली वो फिर करे वो बहन नहीं. Lord, may I pray that it because earlier the counsel who was appearing for the state is no more now Lordship.
All right. Without, he would be more interested in giving you a copy unless your objections are not there. Then he will take time next time.
Item number 16.
May I give you Lord, the order dated 17/8/2017, Lord. The last paragraph, Lord. Lord, the appellant is in custody, Lord, 24/9/2014, Lord. More than 8 years, Lord. Age of the appellant, Lord, more than 68 years.
$68 now.
Appellant age.
As on today.
Yes, today.
Yes, what do you have to say?
My Lord.
What do you have to say on marriage? We are waiting for.
Lord, the medical.
You want time for objections? You want to put some objection?
Your Lordship, of course, if written objection has not been filed but does not require. Victim is 7 years old, Your Lordship. He is a person. He should not be.
But as a rule, we will give you file your objections in terms of 389 to objections may be filed by list after 2 weeks in January.
Oblige.
Item 17. Mr. Shambhunath.
This case, Lord, I am pressing the IA number 118 on behalf of the appellant number 2, Ajay Kumar Thakur. Earlier order was on 1/11/2017.
I have filed written objection.
Liberty was given to renew his prayer after 7 months, my lord. And the allegation against the appellant number 2 is only the weapon which was used in the crime was recovered from the roof of the appellant number 2. Arms appellant number 2 के छत से मिला on the statement of appellant number 1. Appellant number 2 was not participated in the crime. Arms was recovered from the roof of the place. And this is a case of circumstantial evidence, my lord. An informant herself become hostile, my lord. PW1, Munna Kumar Jha declined to have any knowledge of the incident. PW2, Poonam Devi declared hostile. PW3, Kari Chaudhary declared hostile. PW7, Sunita Devi, informant, declared hostile, not an eyewitness. PW6, Manoj Jha, hearsay witness, he has no knowledge who killed the deceased. Only arms was recovered from the roof of the appellant number 2. And he is in custody since 29/5/2017.
Yes. ये तो आप किसकी प्रेस कर रहे हैं मेल एप्लीकेशन?
Appellant number 2, Ajay Kumar Thakur.
Have you seen their objection?
No, madam. Just
I have said.
हाँ जरा देखिए अनेक्शन लगाया इन्होंने.
He is accused in one case. Hindus are accused in losses 7 cases.
He is accused in 2 cases, not 1.
2 cases, the present case, your lordship.
Oh.
2 includes this case.
Include the
First case is this case.
This case, first case is
Second
with
case
the
is some
present
other.
case, your lordship, and second case is the fourth.
328 and 379 the case.
हाँ तो इम्प्रूवमेंट ही है.
दो साल में काफी इम्प्रूवमेंट. 13 का.
और आपके साथी के तो है ही खैर काफी इम्प्रूवमेंट.
वही occurrence
अभी रहने दो थोड़े से. Try it after some time.
I was not participated in the crime, you know. It is the, for only arms was recovered on his statement, my lord.
Paper book, learned people is directed to. After having heard learned counsel, we are not inclined to suspend sentence at this stage. However, learned people is directed to get the paper book prepared, expedite hearing.
और 5 साल हम तो इन्वॉल्व इस क्राइम में नहीं होते, सिर्फ आर्म्स रिकवरी मेरे छत पर से.
आइटम 18
अर्लियर इसको कंसीडर करके 7 मंथ का ऑब्जर्वेशन में गया था. सारा 5 साल हो गया कस्टडी.
Mr. Ram Ajashi.
Loss earlier the prayer for bail of the appellant was rejected by the order dated 13/9/2017 loss, considering the merit of the case loss. Now loss, the appellant loss is remain in jail custody loss for 8 years and 3 months loss.
दो की बेल डिस्कस करिए, एक की बेल
More than 8 years.
More than 8 years?
Yes.
Since when?
Milos, 2 years and 10 months in trial, Milos. And Milos, 5 years, 5 months, Milos, during the appeal, Milos.
8 years, 3 months.
3 months, ji.
No, I'm sorry to intervene, Lordship. At the outset, Lordship, I would like to submit that the written objection in this case has today been filed, Lordship.
All right.
Today itself, Lordship.
Learned counsel for Learned PP submits that written objections have been filed today. Registry to place the same on record. List again next week.
There are two matters. You have filed in 932.
In 932.
And in the other one?
Both arises from the same judgment, Lordship.
So we'll दोनों cases.
Item number 19.
Lordship, there is one mentioning in item number 32, Your Lordship, there is direction of Supreme Court to kindly take up the matter. 32. 32.
112 diamond. Yeah. Arjun, हाँ? बोल रहे हैं.
Item number
32.
Have they submitted their objections?
No, Lordship.
32 में लिख दीजिए.
The case is being listed, but it could not be.
Mr. Sharma, who is appearing in that matter?
Dilip Kumar Sinha.
Name printed. Dilip Kumar Singh name printed.
ठीक है. दिलीप कुमार सिंह को कन्वे करें. लिखिए दी. All right. Learned counsel for the accused petitioner has brought to the knowledge of this court order passed by the Supreme Court dated 10/10/22, whereby the apex court has observed that the sentence suspension application be taken up at the earliest. Learned PP is granted last opportunity to file its objections, if any. List this case next week.
Lordship,
Make a mention on the next day. इसको take it on the
19
court.
also, my lord. No objection has been filed. So they will be directed to.
No, Supreme Court has directed the matter to be taken up.
Lordship,
We don't give you any further chance.
the case which has been called, my lord, 19.
Appellant has been dead at 8 a.m.
Other cases will come up next week.
Lordship, objection के लिए
item number 30.
फिर वो टाइम लेंगे, उस डेट को टाइम लेंगे क्या ऑब्जेक्शन फाइल करेंगे.
आज ये सब कुछ
आज ये
आप लोगों को तो लगा लाख रुपया मिला है तो घोड़दौड़ किए हुए हैं. यहाँ सारा